new enacted criminal law has taken into the account the role and functionalities of all the stakeholders. Now, the best thing what I need to tell you, because we have gone through the entire nooks and corner of the sections, before proceeding, we have added 45 sections. Now, two chapters has been added. If you will see 1973 CRPC, which is now Bharatiya Nagarik Suraksha Sanhita. Now, the previous one was having 37 chapters in total. Now, here, the new one is having 39 chapters. Addition of 2 chapters with addition of nearly 45 sections. Why? Because these things, now at the initial stage, let me tell you, it's not very diverse, it's not very exhaustive, because only the basic changes has been done. And if you will go through, because this session is going to save time of all the learned judicial officers and to make it more fruitful, because there is a shuffling of section provisions. There is addition, deletion, recognition of new concept which has been taken. We are going with the passage of time. We are going to see one by one. And then we will see the 1 or 2 up-to-date recent, just a week before, Honorable Supreme Court has come up with new judgments also. Now, what are the changes? The primary idea is that to bring the victim-centric approach. Now, to balance that, because today, if you will see 20 years before, the rate of reformation approach was not that much effective. Now, today we are living in the era of Hobbes, Locke, Rousseau regime of social contract theory, where the liberty has been given at the center stage. Now, one cannot compromise with liberty. If we recall the judgment of Rudolsa, where we have seen that how a person who has not committed crime was behind the bar for more than 14 years. Now, it was the first case in 1983, Rudolsa versus State of Bihar, because that case is one of the best jurisprudence that the criminal justice delivery system has produced, that how times is challenging and what is the process of trial is determined by case-to-case basis. Each case in the criminal justice delivery system is different from another case. And that is why at the initial stage when I started, I said that there are number of crimes which are yet to come, and it will be more challenging for us. Now, meeting the demands of new crimes, such as now Bharatiya Nyaya Sanhita is having new forms of crime which has been now included, which would have been done earlier. For example, cyber crime. They have asked for chain snatching, organized crime. Now that has broadened the horizon. Now we have often seen Prevention of Money Laundering Act. Now I will start with the concept of the proclaimed offender. It has, this new bnss has enhanced the concept of proclaimed offender. It says that any person who is charged with the offense of 10 or more years can be declared as a proclaimed offender. Now, we have often seen Prevention of Money Laundering Act. Now, it has been correlated with Section 111 of BNSS, which we will see in due course of time. Now, this is the point where I am going to start, that what are the additions and changes which has been made. Now, as I said, there are more than 45 sections which has been added. Now, it is visible from the mark of this slide that now these additions has been done. Now you can see the foremost challenge was challenge of definition. Now you can see the definitions are directly in the when drafting procedure was going on, the stress was laid down that it must be made from common man perspective. Now earlier the definition of bail bonds was not so much flexible. They were symbolical. Now it has directly added the definitions of audio, visual, electronic means. Now there are 2 parts in the definition. Subsection 1 of section 2, which deals with definition part. Now if you will see section 2, subsection 2, which says that the definitions which are not provided in BNSS will be similar or will be taken from Bharatiya Nyaya Sanhita plus Information and Technology Act. Now we have not to move here and there for definition. It has broadened the horizon of definition where we can fix the crime and trial. Earlier, we were not very much flexible with definition, and we said that there was no definition available and we have no power, as original jurisdiction courts of trial courts have no power to define. It is the duty of constitutional court, high courts, honorable high court and supreme court to interpret the law and broaden the horizon. So every time for a new type of cases in subordinate courts, we need to look the judgment of honorable supreme court and high court, that on particular matter is there any judgment, that how trial moves on, and it increases the time limit and it used to cause delay, and in absence of landmark judgment we used to think that how we should try. Now this first and foremost thing has been devised, that they have broadened the horizon of definition. If you will see the definition of bail, bail bond, all new definitions has been added with a rider that those definitions which is not available in bnss shall be taken from Bharatiya Nyaya Sanhita and Information Technology Act. Means in order to meet the demands of modern crime, because mostly modern crimes are taking place with digital gadgets, fraud, financial frauds, number of crimes are going on. So in order to add that, it has broadened the horizon, and that is why the best part is itself visible in Bharatiya Nagarik Suraksha Sanhita, is that the definition part, where it has broadened the horizon of word victim also. Earlier it was section 2, subsection 2 WA, which was victim. Now it is 2Y, and the victim word is inclusive. It includes every person related to the person with whom crime has been committed. For example, legal heirs of the victim has also the right. The dependents of the victim with whom the crime has taken place can also be considered for. Now, this part has to be clarified with the FIR, because FIR is the first step towards the initiation of criminal proceeding. Now, why I am saying that? Because informant, because in next slide we are going to see that what are the advantages of widening the definition of victim. Because earlier when FIR was lodged, it is only the information was connected to the informant. Now if suppose victim is asking for the copy of FIR, SHO or Thana used to reply that we are not going to give you the copy because you are not related to the case. Even though you are victim, we are going, as law says, that we are going to give the free of cost copy to the informant. Now this hurdle has been removed, and this is because victim-centric approach has been taken in order to cover the deliberations and to cover the new dimensions of the law which is visible in Bharatiya Nagarik Suraksha Sanhita. Now then you see the petty offences. This is why mostly required, because in petty offences earlier what used to happen, that even if a young person has committed crime and of petty nature, he used to suffer a lot and it was a victimization for him. Now the segregation has been directly made that it is a petty offense. Often if you will see the POXO Act 2012, it defines about heinous crime, it defines about the gravity of the crime, it also defines number of sexual crimes. Now for that specifically you will have to cover the POXO related cases. But now it has widened the definition, since petty offences has been directly used in Bharatiya Nyaya Sanhita, where the definition has been taken in BNSS also. Now then the power and the jurisdiction under section 23 of BNSS. First class judicial magistrate pecuniary limitation has been enhanced to 50,000, which was earlier 10,000. Now keeping in the mind the fluctuation of economy also, there was a much needed debate on that topic, that why only 10,000 pecuniary limitation on first class judicial magistrate. Now it has been enhanced to 50,000, and the power and pecuniary jurisdiction of second class judicial magistrates has been now enhanced to 10,000. Now the best part is that here we have fixed the role of advocates also. And if you will see, we often, in a layman term, if I am going to say, we were more devised towards that what is the definition of barrister, lawyer, advocate. Now that confusion has been removed. Because from common man's perspective, to avoid the confusion, the only unilateral word that is will be universally used, that is advocate. Now there will be no confusion between barrister, because barristers were the people who used to get the law degree from the England and South Africa, and they have the special recognition. Now that discrimination is now removed. Everyone is on the same pedestal in the nomenclature of advocate. Now, since we are going for the comparison chart, now here is the most important changes which has been made. Now there are two types of FIR now. Zero FIR, which was interpreted in Lalita Kumari case, where Supreme Court interpreted about the zero FIR where there is an offense of cognizable nature. But it was hardly being followed by our SHOs and the justice delivery system. We need a legal backup for that. Now, half of the crime, because day before yesterday, there was one case where entire norms were laid down that why during the procedure of trial, we should be cautious, especially the judicial officers should be cautious at every stage. In due course of time, we are going to see that one. Now, you see, two categorization is zero FIR. Now, zero FIR means independent of the place of jurisdiction. Earlier, the traditional forms of jurisdiction was that where cause of action occurred or where crime has taken place. This two set of principle was being mostly followed in reporting and registration of the crime in the form of FIR. Now, at any place, the main emphasis has been given that the information sharing, which is also one of the standard principle under the international criminal justice system and international law also. From that practice, we have taken that the first and foremost job is to inform quickly to the stakeholders. Now, this zero FIR concept will reduce the delay and reporting of the cases. Now, at any place, suppose I am traveling and a crime has taken place in Muzaffarpur or any district of Bihar, and right now in Patna. So from Patna also I can get my FIR registered. That is the meaning of zero FIR. Now the second type of FIR, which is now under section 173 of BNSS, which was earlier 154, has been replaced by 173, 174 and 175. Now the entire gamut or area of 173, 174, 175 focuses toward a new concept, which is the preliminary inquiry. Now, again, this BNSS has devised the categorization of crime, that crime which has taken place or crime offenses below 7 years. It should be above 3 years, and below 7-year offenses will go through the preliminary stage of inquiry, which will be done by a rank not less than DSP. Deputy Superintendent of Police has been added in this terminology, and within 14 days that preliminary inquiry has to be completed. Now this is going to be a game changer, because there was earlier, if you will see the traditional one, that is the CRPC 1973 code, there was no concept of preliminary inquiry on the part of the police. Now the onus is on the Deputy Superintendent of Police that if the gravity of the offence is above 3 years and below 7 years, in such case, as per the mandate of section 173, 174, 175 of Bharatiya Nagarik Suraksha Sanhita, they have to go through the preliminary inquiry stage. Now why preliminary inquiry? Because it shows the sensitivity on the part of police, and who is going to carry this preliminary inquiry is not SHO. Earlier, not less than SHO was there, but there was no notion of preliminary inquiry. Now it says about that not less than Deputy Superintendent of Police. Means, you see, as you move high, the sensitivity of crime and the gravity of crime moves on. And it is the duty of the state to take care and report and give respite or relief to the victim of the crime. And therefore, within 14 days, that preliminary inquiry report will be prepared and handed over to the magistrate also. So now see, these are the zero FIR mechanism which I have mentioned. E-FIR. Now E-FIR should not be confused with zero FIR. Now E-FIR may be in the jurisdictional domain, or E-FIR may include zero FIR. We have to, at this point of time, we have to understand that what these two new types of, this is nothing new but a creation because of involvement of science and technology and online electronic mode. Because all FIR, zero FIR can also be E-FIR, then what is the difference between E-FIR and zero FIR? Now E-FIR will take 3 days time to come on the register. Entire formalities of E-FIR will be completed. You can see it is written that E-FIR takes 3 days time to put on record. Now there is distinction between zero FIR and E-FIR. Zero FIR means the time words uses, it is independent of jurisdiction. Zero FIR has a special motive why it has to be there in the statute book, because we have to, first thing is that to report the crime. In any case, because it is one of the principle that crime should not go unpunished. And how crime should not go unpunished, because the principle of nullum crimen sine lege, that is the traditional principle. And let me tell you, the basic fundamental of the new BNSS is still following the traditional mechanism. The only change is that mechanism and procedure, that is involvement of science, technology and advancement, because today we are living in the era of internet, which has expedited the movement and transmission of electronic record. So even Honorable Supreme Court since 2007 is in the process of making entire Indian court in the realm of e-courts, to truly make it e-court such that entire thing, we can say paper also, because Honorable Kerala High Court is already the first High Court which has gone totally e-court, paperless High Court we can say, so far as the things or information is moving. So tomorrow or in coming years, we can see that all lawyers and judges will be sitting with only their laptops and their computers without any paper. Everything will be on screen. It will be easy, and will automatically, the motive is to save environment and misuse of paper and all. Now, coming back to that concept, E-FIR is on electronic mode. It is not independent of jurisdiction. Only thing is that you don't need to go to the police station. The main motive behind E-FIR is that victim used to go to the police station and again used to be victimized by the police personals. So in order to avoid, suppose there is a child, there is a woman who often get frightened to go, that I have to go in order to report my own crime, I will have to go to the police station, and what will be the scenario there. So in order to avoid such hurdle and the psychology of the mind, E-FIR has been devised, which will be formally registered. All the formalities of E-FIR will be completed within 3 days. So that is the basic difference between zero FIR and E-FIR, which is devised under section 173, 174 and 175. Now this is the comparative chart which has been made, that earlier you can see section 154 was absent, and there was a hardly, if I can recall, the Delhi is one of the national capital territory where you can use electronic mode of registering FIR, because it is complete, Delhi police is completely online. You can file FIR, but what about the other jurisdiction and other states where police is not having the infrastructure, judiciary is not having that much competent infrastructure? So now one major thing which we will be seeing in coming forth in the slide, that creation of the infrastructure. It has been explicitly mentioned that because it is a very tough challenge for us to have all e-courts, to have the infrastructure before the police to register online mode. So therefore 5 years time has been given from the date of 1st July to create the infrastructure and follow the basic fundamentals which has been laid down in the Bharatiya Nagrik Suraksha Sanhita and all Bharatiya Nyaya Sanhita and Bharatiya Sakshya Adhiniyam. Now the next part is the best part about is that the arrest, because if you will see the entire structure of Bharatiya Nagrik Suraksha Sanhita, at each level it has made certain changes and there has been shuffling of section provision. Now every section provision has been shifted to or replaced by some another section provision. And what it includes, it has done either in the change of timeline and in the change of the procedure which was earlier existing has been removed. Now here I would like to mention before I start, section 8 of CRPC which deals with the metropolitan area and there will be appointment of metropolitan magistrate. Now this word has been removed. There is no, now metropolitan magistrate has no role, this nomenclature has been removed. So this is one of the deletion which has been major deletion which has been made in Bharatiya Nagrik Suraksha Sanhita, that there will be no post of metropolitan magistrate. It will be simply Chief Judicial Magistrate, First Class Judicial Magistrate, Second Class Judicial Magistrate, because now the metropolitan area concept has been, because if you will see, even Patna comes under the metropolitan area, but there were no metropolitan magistrate nomenclature in district of Patna, because any district having more than 10 lakh population will be covered by metropolitan magistrate. But we used to hear the nomenclature in Bangalore, in Delhi, in Kolkata, but in Bihar that was also not notified. So now one rider is there that there will be no post of metropolitan magistrate. Now why this has been done? This has been done to make entire judicial framework uniform. There will be no change in nomenclature in another state in the same post or post of original jurisdiction, that is the subordinate court. So that is why in order to bring uniformity, there will be no change by the state, though this criminal law matters comes under the union as well as state list. It is so now state had number of states has made amendment with respect to that. Now in Bharatiya Nagrik Suraksha Sanhita there will be no such amendment on that terminology, change with the name of and designation. So this is one of the major move in order to uniform the process of nomenclature, that every jurisdiction will have the same process and procedure. Now you can see the arrest related provision. Section 41 to section 41D is now Bharatiya Nagrik Suraksha Sanhita is saying section 35 to 38. Now section 40 used to deal arrest by private person. Now there was no timeline. Now section 40 is converted into section 43. Now there is a timeline that if a private person arrests any person, within 6 hours he has to be submitted or handed over to the police. Now this is again a game changer, because earlier if private person would arrest, there was a word as soon as possible. Now there was no concrete definition or interpretation of as soon as possible. As soon as possible might take place 1 day, 2 day or 18 hours, 20 hours. Now in order to remove that, some person may not take the additional advantage of arresting the person only because he has a power under CRPC, that is now new Bharatiya Nagrik Suraksha Sanhita, that he can arrest any person who is committing cognizable offense. Now as a duty of the citizen, every person has this right, but this right comes with a duty that you have to hand over within 6 hours. Now in order to protect and prevent the misuse of this provision, this accountability is that if you are a private person, by law, if you are not coming under the so-called section 21, that is the public servant, then you have to be, or in the capacity of private person, if you are arresting somebody, you have to hand over that arrested person within 6 hours. Otherwise, you will have to give the reason, justification, or you can also be charged another the wrongful confinement. Because delaying more than 6 hours will invite wrongful confinement and wrongful restraint, which is there in Bharatiya Nyaya Sanhita. So this is one of the change. Now I will like to say about one major changes which has been done in section 43 also. Because section 43 has added the concept of handcuffing. Earlier in CRPC 1973, there was no use of express term handcuffing. And there is, we all know that now the human rights perspective, we have number of the cases and NHRC guideline that handcuffing should be avoided and should be restrictively used in a person who is charged with hardcore crime, or if it is a hardcore criminal and there is an apprehension that he can abscond, then only handcuffing should be used. So there are number of Honorable Supreme Court judgment also. But here it has expressly mentioned that in high gravity crime, handcuffing should be used. So this has been intentionally devised to avoid the confusion that in what cases handcuffing will be there and in what cases handcuffing will not be there. So precisely section 43 provides this procedure that if a grievous offense, for example murder, rape, dacoity with murder, all these provision person is charged with, there is a certainty that police will put restriction by handcuffing, because number of time we have heard that when the accused is presented in the court, he tries to abscond and there is a violence we have seen at number of the places. So in order to restrict these type of misuse, there is express provision of handcuffing. So this is again in Bharatiya Nagarik Suraksha Sanhita section 43. Now all the mandate of the medical examination of the accused. Now there is again a very good initiative has been taken that if in all cases, but highly grievous cases like rape victim, the medical examination of rape victim should be done within 14 days. Means the medical report by civil surgeon or registered medical practitioner should be completed within 14 days. Now this is one of the game changer and a much needed effort which was required, because earlier the court was used to wait and police used to wait for the medical report of the victim that whether rape has been committed or not, and that used to create delay and tampering with the evidences. Now the onus is on registered medical practitioner that within 14 days that medical report has to be submitted to the police and accordingly that should be used. Or if within 14 days it can't be done, then that registered medical practitioner will have to give the reason that what was the reason of delay, because delay invites denial of justice. So that is why one of the best part which has been done is that here. Now this is what the changes in the arrest formalities has been made. Now you see section 157 has now become section 176 of Bharatiya Nagarik Suraksha Sanhita. Now what it says compulsory, which is again we cannot, this is not a time to say that how it will happen, but it is a very progressive measures which has been taken. Earlier I would like to recall that how many cases were investigated by the forensic science lab. Only the high profile cases. Now what about the common man who has been the victim of murder, who has been the victim of rape? Now this is one of the major progressive step which has been taken under section 176 of Bharatiya Nagarik Suraksha Sanhita, that compulsory investigation by the offenses which are above 3 years to 7 years. So all these initiative has been taken that even a common man case, criminal case, will be investigated by the forensic science lab, because in order to ascertain the authenticity of the trial authenticity of the evidences, that real justice can be met out, because we are moving in a very highly technological era where we are talking about artificial intelligence. So now this is that any offense which is 7 or above will be compulsory and mandatorily investigated by forensic examination, and forensic science expert will be using, and they will be produced as a witnesses also. Expert opinion will be taken in such cases. So now this is, and that also, that the expert need not to come inside the court physically. They will be appearing, because in due course of time we will see the appearance will be online to save the time of the court as well as the expert. In foreign countries, if some expert is sitting, he can appear online. There is no need to give a summon that you should come physically and record your statement. So, or give your statement as a witness. So in due course of time we are going to see, but this is one of the major change which has removed the discrimination clause, because as some people or most of the people were of the opinion that the only rich people or high profile cases have the certainty of investigation through forensic science lab, but now any person who is fulfilling, or that case is fulfilling the criteria, that is the offenses punishable for 7 years or more, shall be mandatorily examined by forensic laboratory, and forensic science expert will be used, and their help will be taken in order to expedite the trial. So this is one of the major changes. Now we have already seen this, that no metropolitan magistrate, now this nomenclature has been removed, and new BNSS 2023, that is there is no provision for the post of metropolitan magistrate. Now you see, we have already discussed section 43 is similar to section 40. That must be noted, that section 43 is similar to section 40, which talks about handing over of the arrested person if it has been arrested by the private person. Now the compulsory use and expressed word of terminology, that is handcuffing, which is under section 43 clause 3, is well placed. Moving on, you see the additional provisions of BNSS is section 164 CRPC is now section 184, which we were talking about, that due to delay in forensic science laboratory report, now that report has to be presented within 7 days. Now registered medical practitioner will have to give the report to the investigating officer, which we have seen, and if there will be a delay, then that delay has to come with reason. Within 7 days that has to be presented. Now these are the changes. Now section 167, which is one of the, you can see the liberty clause which we used to say, has become now section 187. Now this is one of the essential development, that the progressive step of section 187 BNSS. Day before yesterday, Honorable Supreme Court in News Click case, that is the case which is a guideline for the remand judges. In this case, let me in a very brief tell you that a UAPA offense was charged against a journalist, and we all know that NSA, UAPA are some of the very draconian sections where there is no provision for bail. But here the Supreme Court laid down that what are the nuances of remand, what are the do's and don'ts for remand when it is done by the judges, and they have to be very cautious, because after illegal arrest has been declared and the procedure of remand was criticized by Honorable Supreme Court, that a cautious approach has to be given. Police always move this approach with a casual manner, because in this case proper communication was not given to the person called Pulkaster, and he was charged with UAPA. Now his contention was that my arrest is illegal because I have not been communicated by the police, and my remand was also illegal. Now he approached the Supreme Court, and Supreme Court day before yesterday passed an order that his arrest was illegal, expressing Honorable Supreme Court in News Click case, the nomenclature, this is very highlighted case of UAPA that day before yesterday passed by Honorable Supreme Court, that a special emphasis has to be given at the remand state also. Now, during remand state, this section comes into the picture, which was earlier section 167 CRPC is now 187. That is why I am attempting to correlate with that, that it has to be exercised with very caution. Now, what is the change? Earlier 60 and 90 days were there. There is addition of 40 days. That BNSS says that 15 days police custody is possible up to 40, 60 and period of detention of 60 days or 90 days. So there is addition. 40 days is a pre-addition. Now up to 40 days also, 60 days. So this 40 days addition is going to expedite the investigation, because earlier the police was to relax for 60 days. So 20 days has been shortcut and 40 days has been added in section 187. Now this is again, yes, earlier 40 days was not there, but 40 days has been added such that the onus will be on the police that you should now don't sit for 2 months, you have only 40 days. In that case, it may exceed to 60 and 90 days accordingly. So this is something which has been added in BNSS, and on the same footing, day before yesterday, the Honorable Supreme Court expressed the meaning of section 167 CRPC, because right now we have to deal with the present law of section 167. So now it will be difficult to get bail in grievous offences. So that certainty has been fixed from the victim-centric approach as well as accused-centric. Why I am saying accused-centric? Because there is, during trial, when we will see the procedure of trial, there is pre-cognizance stage where accused has to be heard. Now there was, prior to that, there was no mandatory observance that during pre-cognizance accused shall be heard. Now there is a rider which we will be seeing that during pre-cognizance accused should be heard. So now this is again a very balanced approach has been that accused defense has to be there at the pre-cognizance stage also. So this is a very value addition to the procedure that both sides, that is the concept of audi alterum partem, now pre-cognizance level also accused shall be heard by the magistrate. Now moving on to the next. Now the investigation of rape and POXO cases. Now the best part is that if we will see section 2, 3 and 4 of BNSS, it has tried to act as a bridge between the special laws. Earlier there was no bridge. For example, as right now I was talking about, nowadays we all are hearing about Prevention of Money Laundering Act. We are hearing about the Enforcement Directorate, ED. Now how they proceed? Supreme Court has laid down that ED will not surpass the procedure of CRPC. ED has to also follow in the special laws the mandate of CRPC. And there is no surpassing of the law because you are under the special law, so you can surpass the basic fundamental mechanism of CRPC. It is not possible. It is illegal. So now the rider has been established by Supreme Court through interpretation, which is now there is no need for interpretation because BNSS is now acting as a bridge between a new law. Suppose a new law will come with respect to another forms of crime. So now we are well prepared that we will be following the step of CRPC, not giving lex expressis a very importance. So there is a bridge that all the mandate of Bharatiya Nagarik Suraksha Sanhita will be applicable in other forms of the crime which has yet to be notified. So the type of crime which the society will be coming in society after 50 years, we cannot imagine. Because here I would like to just mention that there was first electronic murder or e-murder which took place in America. And you will be surprised to know the fact of that murder, that this is one of the type of cyber murder, and that is now taking place, but our investigative agencies are not well equipped, and that is why this change has been made. Now I will go in very brief the fact of that case, that one person was admitted in the hospital, and that hospital was totally in electronic mode, and that was presenting its website what medicines that patient was taking, and online that site was hid, medicine was replaced with poison, and the nurse which used to give the medicine gave that medicine, taking that is a medicine, but it was replaced from the name of poison, and that person died. And that case was investigated by the FBI. Now, there is a likelihood that such form of crime might go unpunished, because we don't have that infrastructure or thinking level that such type of crime may operate. Because today, if you will see, what was the need of inclusion of cyber crime? Every time we used to rely on IT Act. Now, IT Act was done to give enforcement to e-commerce and e-trade, not to enforcement of crime. But when IT Act was enacted, it inculcated, we used to take the help of Information Technology Act to fix cyber crime. If in Parent Act now we have expressly mentioned the definition of cyber crime. We have expressly mentioned the definition of this organized crime. Now it has broadened the horizon of definition of crime, because if crime is not defined, you can't punish. The problem is, for example, mob lynching. Now mob lynching is there in BNS. Earlier, a person charged with mob lynching, what sort of punishment you are going to give? Chain snatching is the best example. Chain snatching used to come under the theft. But if you will go by the wording and the procedure, the way the crime was committed, it is different from theft. Chain snatching was a havoc creating against the females going to the market with their jewelry. They were unsecured. Now BNSS expressly mentioned the crime of chain snatching. Now this will directly move the functionaries to prosecute the offenders, the criminals, and there will be no problem before the SHO or any police personnel registering the FIR, because earlier they used to prove that this is not a theft. They might take the advantage of definition, but now they cannot, because now BNSS expressly mentioned the organized crime, petty organized crime, cyber crime, and that is why I was saying section 4, 5, 6 of BNSS is acting as a bridge with other laws, which will be helpful rather than the person taking advantage of the loopholes. Now the accused cannot take advantage of these loopholes. Now these are one of the major changes in BNSS. Yes. Because see why I am saying, because if you will go traditional form of crime, it is the concept of principle of sine lege, nullum crimen sine lege, means if penal statute is not mentioning the word chain snatching, and if you are writing theft as a chain snatching, you are just replacing one form of crime with other which is not a crime in your statute book. We'll take your question at the end of the session, because this is very interesting question. So we need to complete, and I will clarify all the doubts. Now the one major, because it has been done intentionally. Bilkul. Because this form of crime is directly visible in the society, and our penal statute was not inherently inclusive with that respect. To mention a crime is very important. It was going in disguise, secondary form of the crime, but now you can directly fix that person in chain snatching, nothing else, and the prosecution will be direct. So this is one of the advantage of putting and defining. That is why these efforts has been made. Otherwise, we were still in the situation of prosecuting the criminals of cybercrime also. What was the need of adding cybercrime? Because we had the IT Act. Yes. So now, moving on to the next part. Now, this is one of the, again, major change, that now police will have to update the victim about the progress of investigation. Earlier, there was no such procedure that victim or informant was informed by the police that, see, we are at this level of the investigation. Now, within 90 days, there is a timeline that from the date of registration of FIR, the police will inform the victim about the progress of the crime, such that they can make it more accountable that we are doing something for you. We are not sitting and your crime, the crime of which you are victim, is being investigated and is at this stage. So this is again a very important change which has been done, that sharing of the information of progress of investigation. Now, police officer within period of 90 days inform the progress of investigation by any means, including electronic communication to the informant or victim. Now, informant as well as victim. Earlier, only we used to emphasize on informant. Now, we have to do for informant as well as from victim. That is why at the onset I said that this BNSS is victim-centric. Now, there are some changes with respect to provision of the bail. Now, section 436A has now become section 479 of BNSS. Now, there is a classification of the grant of bail. Now, intentionally and expressly, the bail provisions from section 479 and onward, 479, 480, 481, 482, it has classified the nomenclature and categorization of the offense, that it has expressly mentioned that there will be leniency for first time offender. There will be leniency of people who have spent 1/3 of the punishment. There will be leniency for the people who have spent 1/4 of the imprisonment or the punishment. So it has been, you can see section 479 introduces good practice of providing relaxation for 3 categories. Earlier, these 3 category was there in the form of interpretation of Honorable Supreme Court judgment in Satyendra Kumar Antil and Arnesh Kumar. It was there in the form of interpretation, but now it is visible in the section provision directly, that relaxation and classification. Where now one more thing, the onus is on jail superintendent and the Directorate of Prosecution. If you will go to the provision of section 19 and 20 of BNSS, there is a clause, an additional duty has been added for Director of Prosecution, that it will be duty of Director of Prosecution to identify the prisoners who have spent more than 10 years in the jail. And that report will be forwarded. This is a part of penology, the subject which deals with the part that the procedure which has been taken, that is the penology, that post-conviction and the prison system, which has been intactly visible in Bharatiya Nagarik Suraksha Sanhita. Earlier, the part of penology was not well addressed, but now the Directorate of Prosecution has been given this additional duty that they will prepare the data of the accused convict who have spent more than 10 years in the jail. Why? Because this has been done from the reformative justice approach. That what will be the criteria where state government will be releasing a person for after conviction. Because we might have seen that on 15th August, on the basis of good behavior of the convict, they are released because of old age, or they are released because of their well behavior and reformative approach. So certain jail manuals which is under the state domain, we can see that Bihar has changed its jail manual also. That is going to affect the criminal justice system also. Now this is the rider where the Directorate of Prosecution has been given additional responsibility under BNSS to identify the convicts who have spent more than 10 years, and attempt should be made, because a very good initiative has been taken by National Legal Services Authority also. It has introduced the concept of UTR to identify that there are some person who are not able to get the bail from the jail, who are very poor persons or unidentified person, because recently Honorable High Court identified one case where a convict was in jail, under trial prisoner was in jail for 20 years without representing by the lawyer in the court. So he has been released, and still the major concern is that why these things are happening, because we don't have that sound mechanism inside the prison to identify the prisoners. And day before yesterday, there was a report that every year 50 lakh arrest has been made. In India, every year 50 lakh arrest is being made. Now 50 lakh arrest means number of bail petitions, number of unnoticed prisoners, and Virappa Moli committee report on the prison expressed its concern over crowding of prisons. We have witnessed during COVID era also that how the prison led to the spread of COVID among the prisoners. So now overcrowding of the prison is one of the problem which has been addressed sorry, in the addressed in BNSS, and that is why this fixation mechanism, that the responsibility will belong to jail superintendent as well as the Directorate of Prosecution to identify such convict and prepare a report and submit it to the state government and functionaries of criminal justice system, such that reformative approach may be utilized for rehabilitation of the prisoners. So this is one of the very progressive and civilized approach which has been taken into the account to reduce the victimization of the people or the convicts. Now you see, this is what we have already seen, section 436 to 439 till 450, now replaced as section 478. This is the comparative chart relating to the bail, and there was no definition earlier. We have already seen the definition part, but now you see that this is one of the comparative thing which has to be relooked, because there is an addition of the definition clause. Now we have seen these three categorization also. Now this is pre-trial procedure. Now Cognizance section 190 of CRPC is now section 210. Now that what I was talking, that pre-cognizance stage is inherent here. Now accused must be heard before taking cognizance. Earlier there was no modus operandi, it was the sole discretion of the magistrate. But now you have to hear the accused prior to taking cognizance. So here you can see section 190 has been replaced with 210. Section 193, which is again a very interesting clause is there, which section 193 clause 9 is there. We will come on to that, but let us see the changes and procedural mechanism and the replacement and addition which has been made here. Now section 193 is replaced with section 213. Section 197 has been replaced with 218. Now 197, there is a provision of deemed sanction which has been added. Now provision of deemed sanction, prosecution of judges, prosecution of civil servant. Now there is a 120 days time frame where to seek the clean sheet from the government, and there is a procedure where your senior officer will prepare a report whether you functionary should move with against that person or not. If within 120 days the report is not forwarded, it will be deemed that acceptance has been given to initiate the proceeding. Now this is what the provision of deemed sanction is that. And one for the protection, there is a immunity clause in there in section 197, which is now 218. 218 says there will be a report from your senior officer about your behavior, about your conduct, and on the basis of that report, the prosecution will start or not start. depends upon. Now, if the report has not been forwarded within 120 days, it will be that deemed sanction means approval has been given to initiate the proceeding against judges and public servant. Now, this thing has been done in order to fix the accountability of the people who are enjoying immunity. Now, people who are enjoying immunity are also under the scanner of the law. It is not complete immunity as available to the President of India or Governor. So, on that line, there is both immunity as well as scanner of accountability, because we all know that a person with a higher post has more onus, more responsibility to perform, and they might be fixed under the malicious prosecution or somebody trying to fabricate and frame. So this provision is an addition, the provision of deemed sanction. Now section 209 to 224 is now 232 to 247, means 209 the committal of case. Now committal has come with the timeline. So now within 90 days from the date of taking of cognizance, case must be committed to the session court, which is exclusively trial by the session court. So now what was 209, which is a very, very important provision, has shifted to section 232 that comes under the nomenclature of committal of cases to the session court. So here we are going to see the timeline. You see the provision of deemed sanction, which we have already at the pre-trial stage, that before initiating, if within 120 days that report is not forwarded, there will be a deemed sanction and the time will not stop. The proceeding will initiate against the public servant and judges for their prosecution if they have committed crime or they are charged with the crime. Now, the sovereign immunity clause which I was mentioning, during British regime, during the draft discussion, it was said that right now we are living in the era of equality. We are living for the people and for the society. So why we are getting such huge immunity, unquestionable immunity? So unquestionable immunity has now been eroded. There is no doubt still the enjoyment of immunity clause for the officers, judicial officers, for public servant, but not to the extent of not questioning. They can be questioned, and that idea of sovereign immunity has been over. Over means it's partially, yes, it is there, but now if there is, you have to prove the worth, that why not to proceed against the judges and against the public servant. Now public servant has been given opportunity of being heard regarding the situation leading to the fiasco. So because as we have already seen the guideline by Honorable Supreme Court regarding the appearances of public civil servant in the court, so now that has also been taken into the account. Now pre-trial procedure we have seen. The next part we are moving towards the pre-trial procedure, that is 209. CRPC is now 232. Now 90 days timeline. If within 90 days, if magistrate has taken cognizance and not committed the case, he will have to give the reason that why within 90 days he has not committed the case to the court of session. Because to expedite the trial, these formalities and this procedure has been devised in bnss such that a criminal trial can be moved in expedite manner. So the onus we can see is on everyone. Police is also coming with the onus of timeline framework. Judges are also coming with the timeline framework. Directorate of Prosecution has also been encompassed with timeline, and now we will see complainant and victim should also support the timeline if he really wants to get justice done. So everyone has been made accountable. Now criminal justice system is not in want of only judges and police. It is the onus of the lawyers. It is onus on the victim also to support and cooperate with the investigation such that time-bound justice can be done. Now, timeline for the trial. This is very interesting because you can see earlier session trial start with 225 and onwards. Now, session trial will start with section 250 under BNSS. Now, the major change is application for discharge. Now, a accused can make an application for discharge from the date of committal. 60 days time period has been given that the accused have that much time limit. If he exceed that time limit, he cannot enjoy the fruit of discharge or the right which it possesses. Earlier, there was no time frame for discharge. Now, here the provision for the application of discharge both in magisterial warrant cases trial as well as in session trial, there is a provision, addition of 60-day time limit, that within 60 days from the date of the committal, the application of discharge shall be made by the accused. If he fails to do so, he is not going to enjoy the benefit of this procedure. Earlier, no time limit was fixed. Now, this is again from the rights from the accused perspective. That is why we have to come to the conclusion that BNSS has having a very balanced approach. It will be giving same time opportunity to accused as well as the victim or the informant. So that element of balanced approach has been given in that notion. So section 239 of warrant case is now section 262, trial of warrant cases by the magistrate. And here again the provision of discharge application is there. So within 60 days from the date of committal or from the date of taking of cognizance, both the riders are there, that application of discharge can be made in session trial as well as warrant trial before the magistrate. So that is the trial part. So both, earlier there was no time limit. You can see in the comparison chart that earlier for the session trial there was no time limit fixation for discharge, and even in magisterial trial also. So this is again a progressive step to fix the timeline. Now these are the changes which has been made. Now the changes that there is an express provision for recording of evidence in audio video recording mechanism. Now earlier there was, if you will read the wording of section 351 CRPC, which is now section 274, very important addition. 274 of BNSS provides that magistrate consider the accusation groundless, he shall release the accused as to the effect of discharge after recording the reasons in writing. Now time limit for framing of charge from the date of first hearing of the charge, that has to be taken into, that is very important before pre-trial stage from the framing of the charge, that now there is a time limit for framing charge also. From the first date of hearing of charge, there will be within from that first date to 60 days charge has to be, framing of charge has to be completed. If not completed, that learned judge will have to give the reason in the recording that why delay has been made. Now for every phase, pre-trial stage, trial stage, or during the framing of charge, you can see and observe that there is a time limit fixation is there in order to ascertain the accountability of criminal justice delivery system, which is now we cannot comment on this because this is very earlier that how it will happen. But here right now at particular juncture, we are in the capacity building program to know the what are the changes which has been made. So for that perspective, this timeline perspective has to be taken into the account. Whether it will be successful, not successful is not right now a question. The question is that this change has, this procedural change has been made. So that is why we are here to fix that there is a timeline for even framing of charge, that from the date of first hearing of charge on the charge, within 60 days from that date, entire charge shall be framed in any case. And if not, the reason has to be given in that document that why the I have not been able to complete the charge formalities and the procedure. Now there was no time limit for framing of charge in session trial and warrant trial instituted on police report. So that we have seen. Now there is again the time focus for judgment also. From the summation of argument, when arguments close, an entire conclusion of trial comes to an end. From that date of conclusion, within 30 days, you have to pass the judgment. Extra 15 days time can be given, means you can take 45 days with a reason to be recorded. Now again, this is a very important factor, that now the onus is on the learned judges, that he has to, with the conclusion of the argument, from the date of the argument, 30 days you have to award or pass the judgment in visible form, and that judgment too in online mechanism. Yet it is not visible, but the modus says that it has to be visible on the website also. So there is not far where district court judgment will also be available on the website. So with creation of such infrastructure in future, we can aim that the district court, session court or court of magistrate judgment will be easily accessible on the internet, on the website of the judiciary also. So from that perspective, and that has been also expressly mentioned in that section, that it has to be uploaded. There is a time limit also for the clerks also, that they have to upload. So you can see the accountability factor which has been mentioned under section 258, that earlier many judges were taking too much time for delivering judgment. Now BNSS, to make procedure speedy, it has introduced that judge shall deliver judgment as soon as possible, that is 30 days from the completion of argument, and it may extend to 45 days. When 45 days you can take, you have to give the reason to be recorded in writing. Now that is again one of the very important enhancement and progressive step which has been taken to fix that justice should not be delayed, because delayed justice is a denial of justice. We all are well acquainted with the phrase. Then changes in summary trial procedure. Now this is again a very progressive step, taking the financial economy of the country, means economy of the country, because we see that there is a price rise. So why I am saying, because there were many sections in the IPC which has been now changed in the form of Bharatiya Nyaya Sanhita, where 10 rupees, 50 rupees offences were there. Cattle Trespass Act was there, which was asking for 10 rupees fine. Now there is no meaning of 10 rupees fine. So keeping in such procedure, there has been changes under the summary trial jurisdiction also. That is 2,000 has been converted into 20,000. Now change in pecuniary jurisdiction. Let me tell you that section 260 of CRPC was 260 to 265 of CRPC used to deal with the summary trial procedure. Now it is 260 has been converted into section 283, and it says word which earlier was there, metropolitan magistrate, which has been removed. Now pecuniary jurisdiction has been enhanced for summary trial up to 20,000, which was earlier 2,000, has now up to 20,000. With pecuniary jurisdiction, punishment jurisdiction has also been enhanced from 2 years to 3 years. So this is one of the value addition in the jurisdiction of the summary trial, while taking that which cases will be tried summarily and which will not be tried summarily. So there is enhancement in 2,000 has been converted into 20,000, and 2 years imprisonment has been converted into 3 years. So this is again, you can see the new section under section 283 subsection 2 BNSS, the scope of summary cases has been extended to 3 years. So now it has widened the scope of summary trial also. So this is again an addition in the Bharatiya Nagarik Suraksha Sanhita. Now first time it has introduced section 105. Now this 105 and 111, I am saying 105 of BNSS read with section 111. Why? because it asks for compulsory audio video recording during search and seizure procedure. Now you see, we might have seen that how police used to frame the person by putting some unworthy things and putting liquor, because nowadays in Bihar we can see how much people are being put behind bars because of the liquor. Now this cannot be done by the, or any fall cannot be easily played on part of police while search and seizure procedure, because there is a compulsory audio video recording for that search officer, and within 24 hours that audio video recording will be sent to the magistrate for the reporting. So both the search and seizure mechanism reporting will be directly to the magistrate, concerned jurisdictional magistrate. Now all the police officials who are making out search and seizure during investigation or routine checkup will report that audio video recording within the time frame, that is 24 hours. And special mobile phones are in the process of procreation, that in order to create the facility, because the infrastructure is being created, and that mobile phone will only for the purpose of search and seizure will be given to the IO and SHO and the person who are undertaking the search and seizure procedure, and that report will quickly within 24 hours should be sent to the jurisdictional magistrate. This has raised the accountability part on the investigative agency, because we often used to say that police can do anything. Now they cannot do anything of their whims and fancies. They are under the law, they are under the scanner, and that is the accountability part which has been taken in this section 105. So this is one. And why I said section 111? Because section 111 is very much similar to section 4 of Prevention of Money Laundering Act, which talks about, which has widened the scope of BNSS, because right now PMLA Act is widely being heard because number of well-known politicians are being booked under Prevention of Money Laundering Act. So BNSS intentionally encompasses that provision also under section 111, which encompasses the financial crime investigations where financial fraud are being made and which are a part of organized white collar crime, you can say. You can also say part of organized syndicate crime in the terms of money. So that has special attention has been given to such crimes, because these are the economic crimes which are killing the economy of the country. So in order to take such initiative, that is economic crime has also been addressed under these indirectly by BNSS, and focus on investigation of economic crimes also. Because earlier, if you will see, economic crimes were not so important for that perspective, because crime against offenses against body was more grievous than the economic crime. But now the jurisprudence, there is a change in jurisprudence that both offenses against body and economic crimes has been taken collaterally, has been taken simultaneously, because both are against the state, both are against the country, and both are killing the economy of the country and law and order situation of the country. So that is why I mentioned section 111 of BNSS, read with section 105 of BNSS, which makes compulsory audio video recording of all the search and seizure mechanism. And with respect to the trial of perishable items, there is 30-day time limit, because you know earlier recovery of perishable good was there. Suppose illegal vegetables has been recovered, so that used to perish and there was no productivity coming out of them. Now you have to deal with such search and seizure or such recovery of the items within 30 days, 30 to 60 days, depending upon the nature of perishable quality which it is. So that is what one of the aspect is there. So now this timeline fixation is very, very important. Now I would just suggest these are the main fixation which has been addressed, because we will see that the timeline is very important landmark achievement for criminal justice delivery system. It will surely reduce the pendency of 3.4 crore cases, criminal cases especially, which are pending in the court of law, that from now 1st of July an attempt has been made that such timeline will be focused. For example, section 392 clause 4 of BNSS, 7 days from the date of time limit for uploading, that I was saying, that is the onus on the legal clerks in the court, that from the, if judgment has been pronounced, it has to be uploaded on online format within 7 days. So see the accountability factor, the people who are not directly related to the criminal justice system are also having their role in the either in the clerical form, you can say, but in accountability factor, that it is their duty to upload that judgment within 7 days from the date of pronouncement. So section 392 clause 4. Now section 272 BNSS, time limit 30 days for complainant to appear. Now this is again, if you have filed a complaint petition in the court of magistrate and you are not appearing, so one opportunity of 30 days will be given and then your case will be disposed of. So here the complainant has also onus on the complainant that you appear within 30 days, otherwise lose your case. Now section 262 of BNSS, accused can make discharge application within 60 days from the supply of the copies. So within 60 days from the supply of the copy. Section 258 of BNSS, time-bound conviction / acquittal, which we have seen about the judgment. Section 251 of BNSS, framing of charge within 60 days from the first hearing of the charge, we have already seen. Section 250 of BNSS, application of discharge within 60 days from the committal. Now these are the timeline factor. Now again, section 232, we have already seen the committal of the cases within 90 days from the date of cognizance, which can extend to section 180 days with reasons to be recorded. Section 230 of BNSS, supply of document. Now this was not earlier. Earlier the wording was under 207, as soon as possible. Now that as soon as possible has been replaced with 14 days. That is the supply of the document to the accused. Whatever document is there for the information where accused can use it for its defense must be supplied within 14 days from the date of appearance or production. So this timeline factor is this has balanced from the accused angle also. This has given a reasonable opportunity to prepare a defense, that within, that as soon as has been replaced with 14 days. Now 14 days time rider is there, that supply of document has to be made the time it has been produced before the court. So this is another a very important major change which has taken place. Now section 218 BNSS, prosecution of judges, we have already seen, that is the deemed sanction of 120 days. Section 193 clause 9. Now this is a very important, because sometime during trial a new evidence comes up. Now earlier when trial started, it means that investigation has stopped. Now during trial, investigation can be carried forward with the permission of the court, and again during trial investigation can be carried out. This is section 193 clause 9 is very important. This will be a very game changer for the trial, because now trial on one side is going on and simultaneously the investigation is also going on. Why? Because section 193 clause 9 says, with the permission of the court, investigation can be carried out during trial, but it has to be completed within 90 days. That investigation which is carrying simultaneously with the trial must be completed within 90 days from the initiation of the trial, such that the adequate or the accountable evidence which is collected during the investigation may be taken into that frame during the trial. Now this is a real-time situation which was missing earlier under our procedure. But if new evidences are coming up, you can't give them, because again, there was a mechanism that has been interpreted by Honorable Supreme Court that yes, if new evidence is coming up, that can be taken, but it was having a very, very complex set of procedure. But now, expressly it is mentioned under section 193 clause 9 that simultaneously investigation will be also going on and trial will be also going on, but that investigation has to be initiated or given permission of the court, first thing. Second, that investigation has to be completed within 90 days. It can be extended by the order of the court depending upon the circumstances and gravity of the trial, that what type of offenses are being looked into or being investigated. Now, section 193, BNSS time-bound completion of investigation within 2 months in offenses of rape and POCSO. Now, this was also earlier there because after 2018 amendment and Nirbhaya case where the Justice J.S. Verma Commission report highlighted the expedite the sexual offenses against women or rape or POCSO cases, investigation must be completed within 2 months. So that was earlier also there, but it has been put into the new section in new jacket, that is section 193 of the BNSS in time-bound completion. Now section 193, time-bound progress to be informed, we have seen this is a value addition that informant or the victim is up to date about their investigation progress, that what is the happening, that is just like a right to information. This is what we can call right to information of a victim to seek information about his own case from the police. Now this is the legal binding provision where the police has to give the information. He cannot escape, otherwise victim can initiate another proceeding against the investigative agencies. So this is what the clue has been given. Now section 184 of BNSS, time-bound medical examination, we have already seen. Section 185 of BNSS, copy of search report not later than 48 hours submitted to magistrate. Now effort should be, and CUC recorded of search by mobile, transparency in search and seizure report. Now maximum time you can take is 48 hours. The rider is you have to complete within 24 hours and it has to be submitted in electronic form to the magistrate. Even magistrate will be also provided with the gadget to receive such audio, such recording, such that he can verify, he can note it down, and there will be number of performers. Let me tell you one very important thing, that this BNSS will create addition of new documents mentioned in Schedule 2, because Schedule 2 earlier of the CRPC was dealing with the forms and format. What will be the format of confession, recording of a statement. Now new forms, new statement, new document has been divided where you will have to write down the time when you received the copy, then the time of in how many minutes that video recording belongs to, when you received, when police sent you, all the detailed data per forma has been added to this Schedule 2 of BNSS. So BNSS is having the schedule just like a CRPC, but we will be coming up new performers and new documents, which will be coming up and taking all the measures of the data of all the information mentioned in the column that has to be maintained by police, that has to be maintained by Directorate of Prosecution, that has to be maintained by the honorable learned judges, and that is for the accountability factor that nobody can tamper because it will be in online mode. So even if you want to make change, you cannot change. Then the next part is plea bargaining procedure. Now there is a very landmark change in plea bargaining procedure. Let me tell you the concept of plea bargaining India took from USA, and with the motive of trying the cases in expedite manner, and there is a type of bargaining that is called the sentence bargaining. Now here the person used to take the advantage. What was the advantage? Earlier the procedure under section 265 265A to 265L under chapter 21A is now section 289 of BNSS. Now, time frame, because earlier accused used to take benefit and used to linger the case in the name of plea bargaining. Why? Because at any stage, it was writing at any stage before the conclusion of the trial, accused can give application of plea bargaining. Now, it has been fixed that from the date of framing of charge to 30 days, there is a time limit for giving application. Now, no person can misuse or keep on linger their defense in the name of plea bargaining. Because the idea of plea bargaining was to end the case, to come to the mutual satisfactory disposition where victim will get compensation and time-bound manner, not high grievous cases. Because the ambit of plea bargaining is that 7 year above offences will not be going for plea bargaining. Death, murder and all the of high gravity crime will not be taken for plea bargaining. Only the expressly mentioned was that such offence will fall under the, and even if the victim is allowing, it is all the victim is at center stage. That if victim has accepted that yes, they want to make a compromise with the accused, then only the procedure of plea bargaining moves on. Now there is a time rider. Now the timeline of 30 days is there, and you can see plea bargaining is not applicable if child is below 14 years of age in question. It has widened the scope of plea bargaining. The second thing is that now accused cannot linger, because from the date of framing of charge, only 30 days time period is given where he can give application of plea bargaining. If he gives application of plea bargaining at the later stage, it will not be accepted and trial will move on in its own pace, not in the nomenclature of plea bargaining. So here accused cannot enjoy now the benefit which was allowed under the earlier provision of plea bargaining. Second thing, that total 60-day period has been identified, that within 60 days the cases of plea bargaining from the date of which initiate comes to the conclusion. Means disposal of plea bargaining related cases will be within 60 days from the date it comes onto the level. So that is why now, earlier there was no 30-day clause, no 60-day clause. And for mutual satisfactory disposition, the prosecution lawyer, defense lawyer, police all used to sit together and prepare the report which has to be submitted to the judge. Now that has to be done within 60 days framework, where you cannot enjoy the benefit of doubt which was earlier. That at any stage, whenever the accused used to think that now it's time, the lawyer has given, defense lawyer has given advice, let's move application for plea bargaining, the case will linger for more than 4 months, 5 months. Now there is no misuse of plea bargaining. You cannot misuse plea bargaining on the defense side because of timeline factor. That is 30 days and 60 days. So this is one of the best thing which has developed and new mechanism, because let me tell you, this is the least used section in CRPC. Though we have the provision, but we have very less number of cases of plea bargaining in our district criminal courts. But even then, people used to take the advantage, defense used to take the advantage. So now they cannot misuse this plea bargaining because timeline has been fixed. Now, this is the valuable addition, that is overall summation we have come to. Now, witness protection scheme. Now, let me tell you, there was Neelam Katara versus State of Delhi case. Then you might have known that the Zahida Habibullah Sheikh case about the witness protection, where the Justice Sikri of Honorable High Court in case has also laid down in 2021 case Mahendra Chawla versus Union of India, where the importance of witness was given, and he quoted the words of Bentham that witness are eyes and ear of fair trial. He quoted the Bentham that witnesses are eyes and ear of fair trial. Now, going by that notion, we at state level 2018 have a victim protection scheme under the umbrella of NALSA. But that was not having the legal backup. There is a difference between the scheme and the statute. So a scheme was done as a part of guideline. It was not having any legal backup in CRPC. But you can see section 398 express provision for the first time on the witness protection, that now there is a legal backup for witness protection. If witness can use section 398, the state will have to provide the protection plus compensation also. Now this is something very, very good thing which has happened, because earlier also Honorable Supreme Court in Neelam Katara and Mahendra Chawla and number of the cases, Zahira Habibullah Sheikh case, there was a guideline for witness protection. And all the states, including Bihar, had 2018 witness protection scheme. But it was not duly utilized. Now it will be legally binding under section 398 of BNSS to utilize the notion of victim protection. Now this is best why we are here with expressed legal backup. That state, that is the social contract ideology and theory, that a state will have to protect its citizen if he is a witness and helping in the case. Because Honorable Supreme Court has quoted the words of Bentham that the witness are eyes and ear of fair trial. Witness are very important for fair trial of a case. So witness must enjoy all the benefit which has to be provided in the law. So this will move, and I am sure this provision will ignite and help boost the morale of witness, that there is no need to become frightened or get killed, because you will be getting the police protection, you will be getting compensation in the case of the loss or damage you suffered. So there will be no more victimization. Now, right to free copy of an FIR to victim, a major addition. Earlier, the copy of FIR was only given to informant. Now, victim will also get, if a person is directly or indirectly related to that case, he will come under the definition of victim, that is section 2, subsection 1Y clause, which has been added in BNSS. Prior to that, section 2AA was there for the definition of victim under CRPC. Now, the scope of victim definition has been widened. Now, victim is eligible for free of copy of the documents under section 209 or 207 of CRPC, which was earlier. So that is a value addition to the system of criminal justice delivery system. Now, again one major change, withdrawal of prosecution. Now, number of cases, prosecution used to withdraw the case, whatever the reason may be. Nobody was asking the victim that do you want to withdraw your case. Now, section 360 comes to the aid. Section 360 of BNSS intentionally and expressly mentioned that before completing the procedure of withdrawal of case by prosecution, the words of victim will be taken, consent of victim will be taken. Earlier, nobody was asking in the prosecution that पूछ लेते हैं victim से वो चाहता है कि नहीं उसका case withdraw हो. No consent was taken, but section 360 is a path-breaking achievement that now victim has his say in the case. If it has to be withdrawn, the consent of victim must be taken. So that idea is very much progressive, that now victim has his say under section 360. Now prosecution cannot withdraw without hearing the victim. Now this is what is the real principle of natural justice is. The next part is section 64 of CRPC deals with service of summon to adult male. Now it has been gender neutral. Service of summon and electronic summon is also a new concept which has been added under section 64, 65 and 63 of BNSS, where female member can be also served, because the rider of 64 CRPC was saying adult male member. Now that word has been replaced. Section 66 of BSS has replaced 64 with gender equality. Now, because let me tell you, Bharatiya Nyaya Sanhita has also one very good change. That is the definition of person. It includes male, female, and transgender. So that has been done because if crime happens with transgender, what will be the nomenclature you will be giving? And frankly, let me tell you, transgenders FIR are not being registered because of the confusion between male hai ki female hai. Now it is a gender neutral definition of term person in Bharatiya Nyaya Sanhita, which has been taken by BNSS also, because section 3 and 4 says that whatever definitions, if you will see section 2 clause 2, that definition of Nyaya Sanhita will be also applicable on BNSS, and definition of IT Act will be also applicable on BNSS. So it has broadened the horizon of definition clause, which was not earlier in the CRPC. So this has removed the confusion of definition. It has removed unnecessary complexity and cobwebs. It has removed all the doubt among the police as well as the judges to proceed with the trial directly instead of going for the acute definition what Supreme Court has said, Honorable Supreme Court has said, Honorable High Court has said. Now you need not to rely on anybody. You have expressed provision in the law. So that confusion has been removed. Now this is the last part of the value addition. Trial in absentia, section 356 of BNSS. Now this is again has been taken into the account because it is for the fugitives who moves to abroad after committing crime. We have seen number of the cases, Vijay Mallya case. Right now we have seen one politician involved in sex scandal and has flee to the other country, taking the advantage of jurisdiction. Now this jurisdiction was being, person used to commit crime in Bihar and they used to have his holiday in Nepal. Why? Because using jurisdiction as a heaven. Now in Nepal it will be difficult for the police to go there. Number of letter rogatory and international norms are there to seek approval. But now BNSS has taken a leap forward. That now even if a person has fled to other country, taking the advantage of jurisdiction, his trial will be on and his property will be forfeited as soon as possible. Reasonable opportunity will be given to him. What happened with the Vijay Mallya case also. Now that case study has been directly taken into the BNSS. That what if such, because you see economic crimes are more dangerous than physical crimes. It erodes all the economy of the country. It affects the future generation. It affects the youth. Because huge scam, 6,000 crore rupees scam, 9,000 crore rupees scams are much more dangerous in common parlance also. Equally important, in order to fix that, BNS has taken a special initiative that even if you are out of country, even if you are absconding, the trial will proceed and your property will be forfeited and used by the government for the specific purposes. So there will be no hurdle in the development and growth of the country. So it will fix a crime in a much rational way where they used to think that now I will take the advantage of jurisdiction. Now you cannot take the advantage of jurisdiction. You cannot use jurisdiction as a safe haven. Now accountability factor has been fixed. Now this section 472, mercy petition, it was also one of the major debate which was going, and I am sure section 472, the onus is 30 days and 60 days onus on decision taking on mercy petition. Now Honorable Supreme Court in number of Dhananjay Chatterjee case and number of cases said that if mercy petition are being delayed, a person who is witnessing death penalty is suffering from mental agony. He is continuously in the pain, and if he is waiting that for 5 years, his mercy petition is pending, then every day he is leading his life that tomorrow I will meet death. So what used to happen, they used to get the benefit also. That a person who has been awarded capital punishment is waiting for the order of the president or governor under Article 72 and Article 161 of Constitution of India, that was also taken as a mental harassment of the victim. Here that convict becomes, that person who has been awarded death penalty becomes victim. So decide the case of such person in 60 days. So onus will be on the president and governor and the state government to expedite the mercy petition, either to approve, and one more rider, once mercy petition has been rejected, there will be no provision of appeal, review, revision. It has been expressly earlier also same provision was there, but there was no time limit, and that was the cause of concern. That person has been awarded death penalty is waiting for 5 years, that when finally his mercy petition, and since he is waiting for 5 years, the final was, since you have waited, you are continuously in pain, so we are commuting your death sentence into life imprisonment. So now this thing will not be happen, not be taking place, and mercy petition has been expressly under section 472 expressed to be dealt in expeditious manner, that within 60 days the decision has to be taken. Now the commutation side has also experienced change, where there is a change in the commutation. There will be life imprisonment will be commuted only in 14 years imprisonment, not less than that. So it is a very, very doubt removal that once you have been awarded life imprisonment, it will be commuted not less than 14 years. It will not be commuted in 10 years, or you will be released after completing half of the punishment or such. No, it has been expressly mentioned that if a person is convicted for life imprisonment, his maximum commutation or relaxation will be given is 14 years imprisonment, not less than that. So this is again, this will be the removing the doubt of commutation. Again, there will be more changes, the last part of my deliberation, because there will be a number of amendments also, because penology, as I word the term, that deals with the prison administration and concept of payroll, furlough. Again, this concept is missing. The word furlough and payroll was also not expressed in earlier in CRPC, and this word again is not expressly mentioned. The concept of payroll, furlough, which we often comes to the news that from where these terms are coming, these are still in residing in the jail manuals and the domain of a state government, which keeps on changing. So that area we have to, as a legislation or legislature or drafter, will have to look on. So because we cannot comment on these serious legislation, because it is yet to see the light of the day, and it has to be notified or will be enforced from 1st of July, and unless and until we all will experience, we cannot comment. So it will be precursor for us, and the only thing what we can do, we can sit here and go for sensitization and capacity building, that we can develop such jurisprudence that we can criticize when things are not going seriously after enactment. So thank you for your cooperation and patient hearing. Thank you.
The point which is mentioned by the Sri Ashutosh Kumar, you may summarize it. I will take just 5 minutes to summarize it. Sir has expressed all the changes which he has taken in BNSS. The point which we can take away from here, that is the definition section of BNSS is widened than the old CRPC. Then monetary jurisdiction of first class magistrate and second class magistrate has been enhanced. The concept of zero FIR, E-FIR is included. Copy of FIR is not only given to the informant, rather it should be provided to victim also, that is incorporated. Concept of handcuffing has been further incorporated in BNSS with in certain cases, that is cases of serious nature. Medical report which is provided by the medical officer It must be provided within 14 days during investigation. The role of forensic science and FSL has been incorporated in investigation to make investigation more effective and efficient. Police remand period has been increased. It is increased from 15 days to 14 days and up to 60 days in cases where there is remand for 60 days or 90 days for completion of investigation. Police remand period has been increased up to 40 days or 60 days as the case may be. Investigation of police in rape cases must be completed within 2 months. Victim has right to know the progress of our investigation and trial. Provision of bail has been changed in light of recent judgment of Honorable Supreme Court. Deemed sanction, concept of deemed sanction has been incorporated if the sanction has been not provided within 120 days by efficient authority, then it will be treated as that sanction has been deemedly provided. Committal of the cases has been limited. Time limit has been provided that within 90 days case should be committed. Application of discharge should be filed within 60 days in session trial as well as in warrant trial. After conclusion of argument, the judgment should be pronounced within 30 days or maximum 45 days. Time limit has been given and incorporated. समरी ट्रायल के प्रोसीजर में जुरिस्डिक्शन जो है वो इन्हांस किया गया है 2000 से 20,000 और पनिशमेंट 2 years to 3 years. In both these cases, summary trial could be possible. Audio video recording of search and seizure is must. शेड्यूल 2 में जितने भी फॉर्मेट प्रोवाइड है फॉर्म्स के उसमें भी टाइम लिमिट अब प्रिस्क्राइब किया गया है सो दैट वी कैन calculate the time limit and we can enforce it as mentioned in BNSS. Witness protection scheme has been incorporated. Withdrawal of cases could be possible only after hearing of victim. That is also incorporated. Trial in absentia concept has been developed in cases of accused who is absconding. Timeline for mercy petition is also prescribed. The scope of commutation has been also defined and limited. So in this regard, we can understand and read BNSS, the changes which is incorporated and discussed by Sri Ashutosh Kumar. And we are quite thankful and owing our deep sense of gratitude for Sir kind presence and giving time to us. Sir has not only mentioned what changes has occurred in BNSS, Sir has also tried to mention the justification and thought process behind all these changes. As we all know that this BNSS is now victim, try to balance between the interest of accused, victim and speedy trial. So we are quite thankful for his discussion and his all effort which he has taken to make us aware with this act. Thank you and thanks a lot. We will again gather after tea break within 15 minutes. Thank you. सब लोग जुड़ गए हैं, देख लीजिए।
एक बार बैठ जाते हैं ना। One sir, can you please try sharing your PPT, sir? Just for demo.
Right, 1 second. We will start with भारतीय साक्ष्य अधिनियम, sir.
Yes, sir. Is it fine? It is visible. Thank you.
Right. We will start our session within minutes.
Right, sir.
एक बार पूरा चेक कर ले हम लोग, टेलीकास्ट ठीक से हो रहा है कि नहीं, उसके बाद से शुरू करें।
जी जी जी, हाँ जी, sure. बस वही स्क्रीन हाँ यही जी यहाँ माइक उनको पढ़ा अब परीक्षा देने जाएगा तो नहीं कोई आएगा पूरा लाइट्स ऑफ करके किताब सिस्टम में किया जाता है हमेशा कुछ जैसे मान लीजिए होगा तो जो भी किताब छपने वाला होगा आ जाएगा उसका सिस्टम में कुछ स्कूल वाला देखते हैं चैप्टर हटा कर देखिए वही रहेगा
Shall we start, sir?
Just give me 2 minutes. Just 2 minutes. बलात्कार किया हुआ तब समझ में आएगा, समझा जाएगा। एक पुरुष द्वारा बलात्कार किया हुआ तब समझ में आएगा, समझा जाएगा। अब अपना
ये सर, ये बात करने पे ये आवाज़ उसमें ऑब्जर्व किया जा रहा है, पूरे जसिब में जा रहा है। काइंडली जो है बातचीत नहीं किया जाएगा।
Can start now.
Afternoon to one and all, and welcome back. There is slight change, and present session will be addressed by Sri Subham Srivastava, Assistant Professor, National University of Study of Law and Research, Ranchi, and sir will discuss the newly enacted Bharatiya Saksh Adhiniyam 2023 and changes which is there in Bharatiya Saksh Adhiniyam, and it will discuss in detail by the sir with comparing all the sections with the sections which was there in old Evidence Act and the new Bharatiya Saksh Adhiniyam. Now to sir.
Thank you so much, sir, for this opportunity. Before starting with the discussion, I was just thinking of, see, in the last two sections, we have already had a comparative study of the provisions from Bharatiya Saksh Adhiniyam and the Indian Evidence Act. So I was thinking of discussing these provisions in little detail, if time permits. So before starting with the things, there has been voices coming from different sectors that the procedural laws may be extended to the cases which, even retrospectively, because procedural laws do not have these kinds of negative implications, right? So if the procedural laws are for the benefit of the people, then it may be extended to the retrospectively. Though the provision, the saving clause in the Evidence Act as well in the Bharatiya Nagrik Suraksha Samhita does not say that, but even then, for the purpose of discussion, we may refer to a recent judgment that has come from the Supreme Court. I think last year only, the judgment came, which was about the applicability of the provisions from the Bharatiya Nagrik Suraksha Samhita, or the CRPC, the 1973 CRPC, to the state of Jammu and Kashmir. Since in 2019, the revoke of Article 370 of the Constitution came into effect. So there were voices that CRPC should be applicable to Jammu and Kashmir retrospectively. In Supreme Court has made it very clear that the provisions of CRPC can't be applied retrospectively. So it will be applicable only from the date on which the Article 370 has been revoked, right? So following the same analogy, even for the Bharatiya Saksh Adhiniyam as well as Bharatiya Nagrik Suraksha Samhita, the provisions are to apply prospectively and not retrospectively. So this confusion has to be cleared from the mind. So even the cases that are coming into being reported from 1st July onwards will be governed by Bharatiya Saksh Adhiniyam and the other two new laws, right? The other thing that I was thinking since past few days about the definition of the term evidence. Like, what is an evidence? What all things qualify as an evidence? Whether there has been some change in the Bharatiya Saksh Adhiniyam regarding this as evidence and evidence.
So you all, if you have gone through the definition, the evidence given in the Bharatiya Sakshi Adhiniyam, and it says now that the digital records and electronic records both qualify as evidence now, right? So this is, and also these things are covered within the definition of the term document, right? So the idea under the Bharatiya Sakshi Adhiniyam is to give weightage to the electronic records, the digital records, and treat them same parallel to the documents, the hard copies that we have been traditionally using in the judicial proceedings, right? If you look into several commentaries that have been written since last 150 years, the Evidence Act was in existence in 1872, right? So all these commentaries, they say that evidence is a means to come to find the truth. Evidence is derived from a Latin term, which is evidere, and that is to prove. That means, English translation means proof. So evidence is basically something that allows the court to come to or to identify the truth. But to this, there has been a lot of contentions, and there has been a lot of counter commentary. And let's say, like Tyler says, that evidence, even if you say it's a means to ascertain truth, that can't be truth. That can be only forensic truth. The real truth would be something else, right? So real truth, like if I can give you an example, let's say some incident happens and police fires at, police is carrying, let's say, some person from one place to another, and let's say a group of terrorists attack, right? If, let's say, some police personnel dies and the evidence does not mention, like there is no CCTV footage, there is no evidence to suggest that this is an act of, killing by a group of terrorists, who has killed police personnel. So court might not be able to come to a finding. And the ultimate thing is the police personnel has died. But if there is no evidence to suggest that the police personnel has been killed by this particular person, then the truth remains outside the doors of the court. So court would be able to come to any concrete finding. So it is actually the forensic truth that the evidence allows the court to ascertain, and this thing can be ascertained by relying upon certain facts. Because as Section 5, it was there in the Evidence Act, now Section 3 says that evidence can be given only of facts declared as relevant and of fact in issue. So evidences will come only for these two things, and these things court will consider to come to a finding, and that finding may be referred to as the forensic truth. At the same time, we also have to inquire into the three terms that has been used in the Bharatiya Sakshi Adhiniyam: proved, disproved, and not proved. Same definitions have been borrowed from the Indian Evidence Act. There is no distinction made. There is no change made in it. This proved is one thing for the criminal cases, because this is about a criminal trial. So proved is one thing wherein the conviction will result. Disproved and not proved, the distinction between these two terms would be relevant for civil proceedings but would not be relevant for criminal proceedings, because in both the cases, either it is disproved or it is not proved, the result will be the acquittal of the party, right? And see, one thing very interesting that is used herein, that court, after considering all matters before it, comes to a finding that whether a particular fact exists or particular fact does not exist. So whether a particular fact exists or does not exist, and this is just like a test of a prudent man. And the terms used is not evidence, after considering all matters before it. So that means it is Evidence Act, Bharatiya Sakshi Adhiniyam, is not restricting the judges to only confine them to the evidences that are brought before the court of law. So there may be several other things which do not fall within the technical definition or the technical meaning of the term evidence. Even court may consider that and exercise their conscience and come to a finding, right? So this is the same thing that has been coming from and this, if you go into the background, this is a concept coming from England. The juries were appointed, 12 people were there who would be exercising their prudent test, and the same is borrowed in the Evidence Act. Right. Now I would like just try to share the PPT and show you how differences have been made, and I'll try to discuss on few important points. And what implications that would have. Please let me know if my PPT is visible. Okay.
It's visible.
Thank you, sir. Thank you. Now see, I'll just quickly give you a brief. Under section 1, the references to the court-martials that were convened under the laws of England that have been removed, right? So there is no difference. There is no mention you will find about the Army Act, the Naval Discipline Act, the Indian Navy Discipline Act, and the Air Force Act, which are the British laws, right? Then you may see in the section 3, which was earlier section 3, now section 2, there has been a change in the definition, the headings of the term. Section 3 used to mention the interpretation clause, now section 2 mentions definitions. The second thing I just referred to, the document now includes both electronic as well as digital records. Whereas evidence, you see, I have highlighted with the yellowing that includes statement given electronically as well as electronic and digital records. So additions. So evidence actually now bringing the two things at par, the document that are there in the hard copies and the electronic and the digital records. Just for the purpose of clarification, I just want to tell you that these electronic or digital records, they include the the electronic data that is stored in the communication device, let's say mobile phone, or the electronic data is stored in a computer system or a computer resource, right? So all these terms have been borrowed from the IT Act also, 2000. If we go to the following provisions, we'll see that there is a reference to the Information Technology Act 2000, right? Now what Evidence Act is trying to say, the courts should not discriminate between a document that is brought to the law in the hard copy and a document or electronic record which is produced in the form of a soft copy, right? And you all would be knowing in the previous classes we have discussed that the police reports that are being filed under Bharatiya Nagrik Suraksha Sanhita, they're also being filed electronically now. So that is in fact allowing the courts to consider all those things in the electronic form. Second thing that is important to consider here, like we can draw a connection that since evidences now are given in electronic form and digital records all qualify as evidence, and BNSS, you all know that when police is recording some statement of any person, police is conducting search, police is conducting arrest, or something like that, provisions have been made which suggest that police should actually record the place of occurrence or the statements or the search or the arrest, and all those things will be submitted to the court of law, right? And you would be one more thing. See, the law is allowing. If we go by section 63, which was earlier section 65B of the Evidence Act, 65B allowed giving of certificates. So if you go by the present section, I'll just take you to section 63. Give me a second. See, the 63, in the right side you see the semiconductor memory has been mentioned, which was not there in the earlier under the earlier Evidence Act. Now you see it is saying the optical memory, magnetic memory और semiconductor memory. So ये जो पुलिस रिपोर्ट जो फाइल करेंगी, अभी वो पेन ड्राइव में कर भी सकते हैं, वो सीडी में भी कर सकते हैं, वो डीवीडी में भी कर सकते हैं. तो इसलिए देखिए तीनों चीजों के लिए प्रावधान किया गया है. Optical is talking about the CD or the DVD. Magnetic memory refers to the pen drive or the hard disk, and the semiconductor memory is talking about the RAM. But then you all must be knowing, those who have science background, that we have conductor, we have semiconductor, and we have insulator. So यहाँ पे जो semiconductor लेने की कोशिश की गई है, इसमें silicon based की जो memories होती हैं computer system में, which are let's say in the form of RAM, right, or read-only memory. Right. So they may be semiconductor memories, and all these things which are covered within the Evidence Act in the electronic record definition that is given in section 2. Right. So point that I'm trying to make here is that the definition of the term evidence has been widened to include everything which is either in the documentary form or it is in the electronic. And you also see that from the left side, I have highlighted India in red. So earlier you all know that the Indian Evidence Act did not extend to the state of Jammu and Kashmir. So after the abrogation of Article 370, the Indian Evidence Act, the Bharatiya Sakshi Adhiniyam, will be applicable to Jammu and Kashmir as well. So for the same reason, the special reference to Jammu and Kashmir has been removed, right? And now Section 4 has been merged to Section 2 itself. Okay, so proved, may presume, shall presume, fact, everything is defined in Section 2 in the chronological order. I have just mentioned two very recent case laws that have come in 2024. It says the difference, by Supreme Court only, the difference between burden of proof and standard of proof while inquiring into whether a fact is proved, the sufficiency of evidence is to be seen in the context of standard of proof. If we delve into the definition of the term proved, the proved does not categorize what standard of proof is required, right? It only mentions that after considering all matters before it, the court considers the existence probable or improbable. We're simply talking about the court has to form its own opinion, simply. This judgment is saying that the standard of proof is different and burden of proof is different. Burden of proof is on the parties who wish the court to believe their version, whereas standard of proof is, it refers to the credibility. It refers to the credibility of the parties and the witnesses, which the court in Goa versus Maria Juliet 2024 judgment highlights. The same thing is mentioned in the 2018 judgment of the Supreme Court, that standard of proof is of the prudent man, and the court, after considering all the facts, all the matters before it, has to come to a finding whether a particular fact exists or it does not exist, right? And next you see the reference to the definitions in from the IT Act has been removed from this section, and on the right side you see a general definition has been mentioned, general provision has been made that any reference to the terms in IT Act or the Nyaya Sanhita or Nagarik Suraksha Sanhita all shall be followed in the Bharatiya Sakshi Adhiniyam. So in every place there is no need of defining terms. So the terms which are not defined in the Evidence Act may be borrowed from these three statutes. And then you see Section 3, Section 5, they are same. Section referred to evidence may be given of fact and issue as well as fact, and the same is there in Section 3. Simple, there is one judgment, two judgments that I have highlighted here, that every evidence, same thing, reiteration that in issue and relevant facts सिर्फ इन लोग के बारे में ही एविडेंस किया जा सकता है, बाकी चीजों के बारे में एविडेंस नहीं देना है, कोर्ट्स में कर रहे हैं. And 6 and 7 are same. Section 6 and Section 4, they are same and there is no change in it. Section 6 referred to res geste, you all know this, facts forming part of same transaction. It's an exception to hearsay rule. But the only thing, the test that is applicable for Section 4 under Bharatiya Sakshi Adhiniyam is that there should be spontaneity. For a fact to form part of same transaction, there should be spontaneity. If there is a time given, if there is time gap between two facts happening at different time zones, different places, and there is no connection of spontaneity, then there are chances of concoction. I have written in the last line कि ऐसा हो सकता है कि कोई जो है चोरी फ्रेम कर ले. इसलिए जो है बोला गया कि facts which should be form for a fact to form part of same transaction, it should be connected by a spontaneity of time, so that the person does not have the time to rethink or create his own stories, and that is there in the 22 judgment of the Supreme Court. Section 5 and Section 7 are same. The same 7 has been brought to Section 5 and there is no change in it. Now you see Section 8 is Section 6, which talks about motive, preparation, previous and subsequent conduct. Now there has been a lot of debate around what conduct is and whether a particular thing forms part of conduct to be relevant under Section 6 or not. So let's say there is one judgment that has come in 2022, wherein the Supreme Court has an option to examine whether a particular fact is part of conduct or not. So if let's say a person is relying upon in the present will, referring about the revocation of an earlier will, that is conduct. So simply, if any person does something which suggests that the court, that some connection can be established about that court will have the option to examine, right? So when a party is making a claim based upon revocation of earlier will as indicated in a subsequent will, said acknowledgement of former would form part of conduct leading to a relevant fact. A person going to a police officer for the purpose of lodging an E-FIR is conduct. A person killed someone, went to the police, give the information to mislead police, to mislead investigation, that is conduct. Conduct, previous conduct and subsequent conduct. Previous to the happening of the incident, person behaved in a particular manner, that is conduct, right? So all that should be covered within section 6. Earlier it was in section 8. Section 9 is now section 7. Facts which explain or introduce a fact and issue. So facts which establish the identity of a particular thing or a particular fact is relevant. So the TIPs that have been conducted, the test identification parades, are relevant in section 7. You all must be knowing that under Bharatiya Nagrik Suraksha Sanhita, provision has been mandatory made, that it is mandatory that in every case where a TIP is being conducted, it shall be videographed. Now section 7 is to be read with Bharatiya Nagrik Suraksha Sanhita. Now you see, investigation parades, that as mentioned herein, the facts necessary to explain or introduce, these investigation parades or identification parades would not hold much relevance if the person who is trying to identify already knows the identity of that person. So there have been a series of judgments which say that the TIPs become mandatory when the offender is unknown to the victim. If the offender is unknown to the victim, then identification becomes relevant, it becomes important. If the offender is already known to the victim, then it is not necessary to go for TIPs because it is already known. And for the same reason, you refer to the Jessica Lal murder case, the Manu Sharma judgment came in 2010. There has been no series of guidelines issued coming in that the identity of the offender should be protected, identity of the accused should be protected, the photographs should not be released in media, and when even the photographs are being taken, the face should be covered so that the photograph or the identity is not revealed to the general public, including the one who is willing to identify. If he already knows that this person is to be identified, then there is no point of conducting TIP and the proceedings will be vitiated. It will not be amounting to a fair kind of proceeding, right? Now at the same time, you see, you all must be knowing that TIPs should be conducted immediately after the information is received. And if we connect this provision to the forensic science domain, we all know that there is a PBS system and there is CBPS system. The informant will inform the police and then a sketch will be prepared. On that basis, arrest shall be made. And these things should be conducted immediately. If time passes, it will be giving an option to the defense to take away the case from the prosecution side. Because memory fades, we all know that. And see, there is a lot of jurisprudence that has evolved into this. If we refer to certain books from neuroscience, like Phantoms of the Brain, it suggests that memory fades and every person has an imaginary picture in his mind. And from that imaginary picture, he tries to identify the present person. Okay, so it should be conducted immediately so that there is less chances of forgetting the image that the person has captured in his mind, right? Going further, section 10 is section 8, there is no change in it. 11 is section 9, there is again no change. Section 12 is section 10, there is no change, just the terms have been rephrased. The concept, the content is same. Section 13 is section 11, talking about right or custom. existence of any right or custom, the transaction is relevant as well as particular instances. So a judgment of a court relevant from where a particular right or a custom which was once claimed and it was acknowledged or allowed by the court, that is what a transaction through which certain right was created. Okay, and let's say some cases filed. See, in 2002 judgment in a previous suit between same parties is a relevant piece of evidence if it has no material bearing on the controversy arising for decision in the subsequent suit. In simple terms, if two parties are at dispute and some judgment is passed between the two parties, then in a subsequent proceedings between the same parties, the previous judgment would become relevant, because that is one instance where court acknowledge that you have certain right. Right, so section 13 is allowing it, which is now section 11. Section 14 is section 12, talking about the existence of state of mind or bodily feeling. Whether an act is an accidental one or intentional one, that was there in 15, is now in section 13. So this is again talking about signature crimes, where a person, let's say, just for example, there has been cases, many cases, wherein, let's say, a person purchased several houses, and in one house it was found that a kid was killed by him and it was buried under the land. Then investigation was done and it was found that this person purchased several houses, and in every house he used to live, and he used to kill people, children especially, and he would bury the kid within the ground and then he would sell that house. Similarly, there have been cases wherein a very famous case of bride in the bathtub. There was a case in we study in foreign science also, that a young lady, a married woman, was found dead in a bathtub, and especially in such cases, there are doubts whether it is homicidal death or accidental death, because in bathtub the height of the water is not that much that person of healthy build can drown automatically, right? So investigation was done and it was found that this person who was the accused, his husband only, he would marry people and kill his wives in a similar fashion. And he had married two people earlier and killed his wife in the same manner. And in both the cases, brides were found dead in the bathtub itself. So what he would do, he would forcefully kick on the legs of the victim, and so that the victim would die, fall back, and then he would drown the head of that victim within the water, and that would lead to death by drowning. Right. So this is about signature crimes being committed by psychopath criminals. That is covered in section 13. Now, section 16, which talks about the course of business, is now in section 14. So there is, like, let's say, whether a particular act was done or not. So let's say we drop check in the check boxes at the bank. We go to the bank make check box hota hai, the check dala. So whether the check was taken from there, it is cleared or not. So there is a standard operating procedure. In the course of business, anything that is dropped in the check box would be taken for the purpose of clearance. So that is presumed, anything which is in the course of business, it would have been presumed to have been done. Likewise, there are letter boxes at the post offices. Those post office mein jo letter dala jata hai, as a matter of practice, as a rule of business, course of business, that letter is taken and it is sent to the address that is mentioned on the letter. So these things will be relevant in section 14 of the Bharatiya Sakshya Adhiniyam. Now, section 17, which defined admission, is covered in section 15, and we all know an admission is just a statement which discloses an information, gives an information. It can be in oral form, it can be in documentary form, as well also in electronic form, right? Because Sakshya Adhiniyam is allowing it. Okay, and see, we all know that admissions are not the conclusive proof, but they may act as estoppel. But at the same time, there are judgments coming in from the courts that even if there is an admission coming from a party and the entire admission can't be accepted, then that portion of the admission which appears to be truthworthy, that may be separated and that may be accepted. So as a general rule, it is said that admissions should be either accepted as a whole or it should be rejected as a whole, right? But if it inspires the confidence of the court that some portion of the admission is true, it's truthworthy, and it can be corroborated on material particulars, then that may be admitted by the or allowed by the court. Section 15 talks about it. You can see there is a series of judgments that I've mentioned here, wherein who may make admissions. Admission may be obviously made by the party to the case or his agent. So that is mentioned even in 2020, one recent judgment came wherein unequivocal statement made by counsel authorized to appear on behalf of the client in relation to the latent's commitment, lacking any explicit instruction to the contrary, is binding on the client. So if the client has not said something to the contrary, the lawyer who makes an admission or a statement will be binding on the client. And section 19 has come to section 17, there is a shift of two sections. 20 is section 18. 21, which talks about proof of admissions against person making it. So we all know that admissions generally, like parties cannot be allowed to create evidence in their own favor. So admissions are majorly allowed against the party who makes it, right? But in the three circumstances, the admission in favor of the party who makes it may also be allowed. That is from section 21. Now it is in section 19 of the Bharatiya Sakshi Adhiniyam. Now 22 says that oral admissions to the contents of documents are relevant. That is now section 20. Two sections. Now 22A has been removed. So in simple terms, electronic records ka oral admission nahi dena hai. Electronic records is a document, right? And electronic records, obviously, they are vulnerable to tampering and all. So it is being said that 22 is removed and electronic records should be brought to the court for the purpose of inspection. Now you see 23 is section 21. The reference to a barrister, pleader, attorney or heel, this were in existence since the time of British rule, so they have been removed, and at every place the term advocate has been used. Now from Bharatiya Sakshi Adhiniyam, Bharatiya Nagarik Suraksha Sanhita, both these statutes, all these terms have been removed and have been replaced by the term advocate. So parallelly, I believe the Advocates Act also need to be amended, and these terms may be removed from the Advocates Act also. Now you see section 24, 28 and 29, all these three sections have been merged together, which talk about extracted confessions. We all know that confessions, they are admissions only, right? Admissions are the statements, and the definition as propounded by the Privy Council in the Pakla Swami judgment, that confession is what? An acceptance of guilt. So a person may simply come to the court and tell that he has committed the crime. In clear particulars, he might say that. At the same time, the person might not understand the intricacies of law. So he might just state the facts which constitute crime. So as per Pakla Ryan Swami judgment, both will qualify as judgment, as confession, that whether the person says in clear terms that he has committed a crime, or two, he says that, yes, he admits that these are the facts which he has committed or done and which constitute a crime, so that both these two things would qualify as confessions, right? Now, we all know that coming into BNSS and this thing, Bharatiya Sakshi Adhiniyam, confessions need to be voluntarily made. Because we have Article 21 and Article 20, Clause 3 of the Indian Constitution that says that no person accused of an offence can be forced to be a witness against himself. So in simple terms, a person cannot be compelled to accept that he has committed a crime. That would be violation of his fundamental right. So in simple terms, a person should not be compelled to say that he committed the crime, right? So for the same reason, 24, 28 and 29 were there in the Evidence Act. They have been merged into 24. And for the same reason, we have section 164 of the Bharatiya Sakshi Adhiniyam, which is now section 183. 164 of Bharatiya, CRPC, which is now section 183 of BNSS. It lays down the protocol, how confession should be recorded, and all confessions should be voluntarily made, right? If you go by the heading of the section, it says confession caused by inducement, threat, promise shall not be relevant, right? At the same time, if there is a confession which is made under the after the impact caused by inducement, threat, promise has been removed, then it becomes relevant. And at the same time, if a confession is otherwise relevant, it shall not become irrelevant merely because it has been made under promise of secrecy, or some deception, or some cheating, or under the state of drunkenness. तो कहने का मतलब ये है कि confession should not be extracted one. No one should be compelled to confess that he has committed a crime. But at the same time, a person may voluntarily wish to say something, to confess, then the magistrates are under the obligation, recording under 184, 183 BNSS, to warn them that you are not bound to confess and what consequences will it follow if a confession is recorded by the magistrate. Right. So you see these three sections have been merged into section 22 and there is no change in it. At the same time, there's one thing that is I wanted to highlight is confession actually is deriving from the term admission only. And all the provisions from Bharatiya Sakshi Adhiniyam, they nowhere mention that the confessor should communicate a particular thing to a particular person. That means the law does not compel that there should be a two-way communication when a confession is being recorded. The provision nowhere mentions. And for the same reason, the Supreme Court in Sahu versus State of UP in 1966 concluded that intention to communicate is not a necessary component of recording confession. So in simple terms, if a person is talking to himself and someone overhears it, that is allowed as a valid confession. That is an extrajudicial confession. Similarly, a person might just talk to himself and walk on the road, and if someone overhears it, right, as in the case of Sahu versus State of UP, that will be allowed as a valid confession, right? At the same time, there are judgments, the recent judgments coming from Supreme Court only in 23, that Prabhat Bhai, Bhai, Devi versus Gujarat, State of Gujarat, that courts should be very cautious while recording extrajudicial confessions. So confessions which are made to any person other than a judge is considered as a weak piece of evidence. So a lot of responsibility has been placed upon the judges to find out to whom the confession has been made and what is the credibility of the person who has recorded the confession. So you all understand that confession to police can't be proved in a court of law, but there may be cases wherein some person makes a confession to any person other than a police officer, right? So that is relevant, but that should be, that should inspire the confidence of the court, and the court in this judgment refers to them as sterling quality. So that means the court is cautioning the judges to consider extrajudicial confessions only when these who are telling the court about the confession, they are of sterling quality and they can be believed undisputably, right? Then next, you see 25, 26 and 27 have been merged together and there is now section 23. Earlier, the heading of this section 25 was confession to police officer not to be proved. Now the term not to be proved has been removed and the section has been neutrally drafted. In simple terms, confession to police can't be proved. Confession to police in police custody, if that has led to the discovery of any material thing or material fact, then that portion of the statement which has led to the discovery can be proved. Recently, I think few months back only in Ranchi, there was an incident. There is a Dhurwa Dam in Ranchi, and an incident happened wherein a person killed his infant child and he threw the dead body in the Dhurwa Dam itself. And he told his wife that he has sent her infant child to her maternal house, to her relative's house. 2 days passed and the daughter did not return and there was no information about it. The wife lodged the police complaint, police arrested this person and this person gave information to the police, took the police to Dhurwa Dam and the dead body was recovered. So this is just an application of section 27 as it was in the Evidence Act, and now it is section 23, proviso to section 23, right? And also one more thing, it says that subsection 2 of 23 says no confession made by any person while he is in the custody of a police officer unless it is made immediate presence of magistrate shall be proved against him. So it is talking about a situation wherein it is just giving an instruction, a general instruction that अगर पुलिस कस्टडी में है तो confession magistrate के सामने दिया जाएगा तभी वो relevant होगा, otherwise it would not be relevant, as is there, and the detailed procedure is laid down in section 183 of BNSS, which says that no, you have to give warning to the arrestee or the confessor if you think that you have a belief that the person is suffering from inducement that promise, then you should give cooling off period to that person so that he can come out of the impact or the effect caused by inducement threat promise at the hands of police, and then his confession should be recorded, right? Then there is a provision for appointment of a translator. Then after the recording of confession should be read over to the confessor. There should not be any administration of oath when confession is being recorded under 183. So all these safeguards and parameters are laid down in section 183, and here it simply says a confession in police custody would be relevant only if it is given in the presence of a magistrate. Next, we may refer to the recent judgment from Supreme Court in 23 that there are a lot of voices. If you remember the Devman Upadhyay judgment also, and there was challenge that Article 27 violates a right to equality in the Indian Constitution. So it mentioned that discrimination is being made between a person who is in police custody and person not in police custody, right? So the confession, the section 27 is designed in such a manner that it is allowing confessions which are made in police custody, though there may be chances of inducement threat promise, while it is not allowing confessions which are not in police custody, made by person who are not in police custody. So in Seizure Kuren versus State of Karnataka 23, Supreme Court is saying that there can't be a general presumption that a confession is, if it is coming from a person who is in police custody, it would be false. It can't be automatically false. It can't be automatically presumed that the confession has been a result of a compulsion. Court has to examine in each and every circumstance whether there is any inducement threat promise or not, right? At the same time, while inquiring in Manjunath versus State of Karnataka, Supreme Court, last year only, 23, while examining what would amount to discovery, because see, if you refer to this section, the proviso to section 23, last proviso, it says, provided that when any fact is deposed to as discovered in consequence of the information. The term used here is discovered. It is not recovered. Recovery is something wherein the court says it may be presumed that you already knew about it, right? Or you had the opportunity to know about it. Here the term used is discovery. So the information that is coming to the police, which has led to the discovery, must be such that police would not have recovered it or discovered it unless there was this information. As I gave you the example of Dhurwa Dam Ranchi case, right? Police would not come to know about it whether there was a dead body hidden in the Dhurwa Dam itself. Nobody can foresee that there would be a dead body there. So that is covered within section 23 and not everything. So the court says that recovery of weapon from open places, excess all, is not reliable. It is not discovery within the meaning of section 27 and now section 23. Section 30, that is talking about joint trial, confession of co-accused, is now section 24 and there is no change in it. 31, as it was, confession admissions are not conclusive proof, but they may act as a stopper. That is now section 25. There is no change. There is now some change in this section, so 32, which is famously referred to as the dying declaration provision. Now it is moved to section 26. And the 8 subsections that were there in section 32, these subsections heading has been removed. And these headings have been converted into simple sections. Right? So if you have the Bear Act, you may see under 26, only clauses are mentioned A, B, C, and D, and the headings have been removed. So it will not have any impact on it. It's just the restructuring of the provision. As also, dying declaration, there has been some series of judgments which say that attempts should be made to obtain the medical fitness certificate from a doctor. But if there are no chances, there are no scope for recording the getting this medical fitness certificate, then declaration may be recorded by any person, and attempt should be made to record it in the question answer format. Because we all know that a witness, a competent witness is someone who is able to understand questions and answer them logically, right? For the same reason, these requirements have been listed down, that if it is recorded in question answer format, then court will have the opportunity to examine, by looking at the question and the logical answer, that the person who made the declaration was in a position to understand the questions and answer them logically, right? So these requirements have been made. Then now, since we have under the BNSS that there should be video recording of these things, so attempts should be made, and it should be informed to everyone that while recording dying declaration, the mobile camera recording would be of much use and much relevance, because this can do away with the question answer format. Because question answer format also has one kind of limitation, and that is person might hint the declarant that he has to say something, and that hint or thing may not be recorded in the paper in the question answer format. So if there is a video recording, that would be obviously a better piece of evidence as compared to a written record under section 26. Now you see, there is one more judgment coming from Supreme Court in again 23, Manjunath versus State of Karnataka, that presence of magistrate in recording a dying declaration is not necessary, is not mandatory, but it is a rule of prudence, right? So if there is an opportunity, there is an option available, there is time available, then magistrates may be there. But if there is no time available, a person might die at any time, right? Then the absence of magistrate will not vitiate the proceedings. And then there may be cases wherein there may be two or multiple dying declarations. Then what should be done? So there is a judgment from Supreme Court in 2022, State of UP versus Veerpal. And so Supreme Court says that courts must examine. So there can't be a general presumption which would be that the first challenge shall not be preferred. And because there are contrary judgments also coming from the court, if there is a first dying declaration made and there is a subsequent also made, and before the subsequent dying declaration was made, declarant met with, let's say, his family member or someone else. So then again, there are chances of concoction. There are chances of creating of stories, that the first one should be preferred, it is good, and the second one should not be preferred. So we do say is that all the time to be covered by the court. As I say,
sorry to interrupt you. We are running out of time, so please conclude your sentence within 15 minutes if possible. We will continue after that.
Sure.
But in next 15 minutes, try to conclude.
Right. Sure.
Thank you.
It can't be. And see, one thing very important for we to understand is that circumstances do not lie. Witnesses may lie, but circumstances don't lie. So that court should consider all the circumstances. Now 33, section 27, there is no change in it. I just skip through the sections which are which do not require any discussion. 34 is 28, no change. Again 36 to 30, no change. Now 37 may, the reference to Parliament of United Kingdom, all that has been removed and replaced by, see, section 38 too. And in the recent times, you have seen that the books, the law books are now coming in electronic format, like SCC Online is there, ABC Reader is there, and there are several other platforms which allow judgments to be produced before the court in soft copies, in soft form, right? So for the same reason, 32 mentions that books may be in hard copies as well as in electronic or digital form. Section 39 is section 33, there is no change. 40 is 34, no change. 41 is 30, there is no change. No change is the judgment that I mentioned. Again, no change, only one change from section 43, which is now section 37. One illustration has been deleted, right? But there is no reason for deleting it, but the law has deleted it now. 44 is 38, there is no change in it. Now 38 is talking about this thing, judgment that has been obtained by fraud or collusion. Okay, so the Supreme Court in 2017 judgment, Chandro Devi versus Union of India is saying that just because an adverse order has been passed, right, or some wrong has been committed while delivering the judgment, that does not lay a presumption that there was a fraud in that case. Okay, or judgment has been obtained by fraud. So these clerical errors may be removed or rectified at later point of time. Now 45 and 45A, these two sections have been merged into section 39. This is one change, the expert evidence. And one addition is there, that the ambit of this section has been widened. You see, on the right side, I have mentioned, or any other field. So now, courts have the power to call for expert evidence in any field, not just limited to foreign law or science or art or identity of handwriting or finger impressions. It can be any field. There are judgments which I have mentioned here. Again, Supreme Court is saying that expert evidence is of persuasive value. It should not be given precedence over the direct evidence. So direct evidence should be more credibility, more weightage as compared to an expert evidence, right? And see, all these things, I came across this very beautiful line from the judgment, that the trial court is like a historian attempting to reconstruct the past, and that, like every historian, it engages in a conjectural undertaking. In simple terms, all these facts which the court is allowing before it, all the evidences that are coming to the court, these are for the purpose of the court to reconstruct the place of occurrence, to re-examine it, like a historian who would mention things, study things in detail from beginning to the end to come to a conclusive finding. Section 46 is section 40 and there is no change in it. 47 is 41, no change. 47A has been removed. Opinion as to digital signature, right? So under BSA there is no parallel provision because in simple terms, digital signatures may be opinion की जरूरत नहीं है यहाँ पे. It can be proved by the public key infrastructure that we have. All the certifying authorities may be of digital signature. That certificates may be produced for the purpose of proving the digital signature. No change. Then again you may see 49 is 43, no change. 50 is 44, no change. 51 is 45, no change. These are same sections. Just renumbering has been done. See, all these sections are same. Just judgment on this point. When it is about the taking of judicial notice. So mention one case from Supreme Court that came in 2020. Then you see that section 59 has been amended a little bit and it is now 54. The term electronic records has been removed from here. It says now all facts except the contents of documents may be proved by oral evidence. That means for electronic records, oral evidences are not admissible, right, at all. You see, it is about this thing. 55, oral evidence shall in all cases whatever be direct. That means hearsay evidences are not allowed. And on the same point, there is one judgment that I mentioned here. I'll share these slides again with you, so you may just go through these things. Now you see section 62 is section 57. There is no change in it. Just the paragraph that was there in section 62. The paragraph has been renumbered explanation, no change. 63 is now section 58, and there is one change. Secondary evidence means and includes. So means term has been removed, and it simply says secondary evidence includes. Now this term includes means the ambit has been widened. The ambit of this section has been widened, and it refers to oral admissions, written admissions, and evidence of a person who has examined a bunch of records. So in simple terms, it is trying to say there are 3 more additions to what qualifies as secondary evidence. So all oral evidences, admissions, all written admissions, as well as opinion of some person who has examined documents which are voluminous, because these voluminous documents court may not have time to examine. That is also qualified as secondary evidence. Now see that section 61 has been removed, newly added in section Bharatiya Sakshi Adhiniyam, and there was no parallel provision in this thing, Indian Evidence Act. It's simply saying that all the electronic records and documentary evidences, digital records or electronic records, shall be treated at par with the hard copies. They shall have the same legal effect, validity, and enforceability. Right? So again, coming to 65A is now 62. There is no change. Now here is some change that I was referring to. The ambit of section 63 has been now widened. So now it has mentions the semiconductor memory, which is produced by a computer or any communication device or otherwise stored, recorded, or copied in any electronic form. So it is simply trying to say that data which is electronically stored in either of these 3 formats, either optical, magnetic, or semiconductor memory. Semiconductor memory simply refers to RAM or ROM, right? That is covered. And lastly, it says, or copied in any electronic form. So it is now not distinguishing between any form of storage. Now, there may be future inventions also. That may be changed also. So it has been so wide that for future changes also it has given scope. And you see one more thing. The term communication device has been added everywhere. You see here also, subsection 2, communication device. Reason being, these communication devices now are acting just like a computer. And what is a computer? A computer is a device that is capable of performing memory functions, arithmetical functions, or logical functions, right? So mobile is performing the same thing. So this definition has been widened. Otherwise, last also, this thing, few changes have been brought. Provision has been simplified. It is talking about these devices either working in a standalone mode, singly working, or it is working in a form of a network or a setup, a web of systems working together. All that has been incorporated within this. And lastly, one change that is brought, because earlier it was not there and there was confusion, at what stage the expert certificate should be submitted. Now this section is clarifying that it shall be submitted along with the electronic record at each instance where it is being submitted for admission. That means every party is submitting the this electronic record, he should submit the certificate. And now there is one more change. 2 formats have been attached. You may refer to this format. One format is to be signed by the party and the other is to be signed by the expert. A party जिसके पावर और कंट्रोल में है आपका सिस्टम, वो सर्टिफाई करके देगा और दूसरा एक्सपर्ट को हैश वैल्यू के साथ नोट करना होगा, right? And just to highlight one recent judgment that has come from Madras High Court, 2023 judgment only. And you see that the judgment holds relevance. Reason being, earlier the law was not mentioning about the hash value. Now this expert format that is attached, it mentions about the hash value. If we see on the screen, now this judgment is saying that कि hash value जो है expert को 4 stages में record करनी चाहिए. When the CCTV footage gets stored in the hard disk with the permission of the court for examination by the analyst, and this is one stage. When analyst creates a copy image of what is contained in the hard disk, this is second stage. Third stage, when the forensic examination starts, and fourth stage, when it is concluded and the report is submitted. And in all these 4 stages, if the hash value is same, then it may be concluded that the electronic record has not been tampered with. Right. So this is again one landmark judgment that has come from Madras High Court recently. Otherwise, section 66, 64, there is no change. Only terms have been restructured, rephrased, no change. Again, reference to UK has been removed. The judgments have mentioned. Again, no change. No change. You see, this is about the opinion of an expert, wherein signature has to be compared. So Supreme Court is again saying that court can't compare disputed signatures with admitted ones by mere glance. Must record analysis of characteristics. So expert should be called to compare signatures, but at the same time, courts are also saying that opinion of expert is not the ultimate truth, because there may be family members, there may be acquaintances who would be aware of the signature and the handwriting of the other person, right? So that may also be allowed and considered. Again, 73A, section 73, there is no change. Just explanation has been removed from 73A because in section 2, you already know that all terms which are not defined here may be borrowed from IT Act. So likewise, they have removed this explanation. 74 and 75, they are merged together. Public and private documents now. Now there is a series of judgment titles. Supreme Court in Ram Jethmalani versus Director CBI listed down a series of documents which would qualify as public documents. So I have mentioned these things, you may see on the screen. Then I have also mentioned there are series of judgments through which certain documents have been declared to be public records like FIR and charge sheet or Hindu marriage register, records of nationalized banks, school leaving certificate, birth and death registers of municipalities. All these are public records. Then medico-legal case reports, all these are public records, right? Then there is a list of documents which the courts have said they do not fall within public records. So they have mentioned that also, you may see. Then moving on to this thing, no change, same. Again, reference to crown and representative have been removed. Same thing here also. Provisions have been Indianized. Again, no change. Provisions are same. One judgment like statements recorded in 164 CRPC, now 183, they are presumed to be genuine, but does not guarantee truth. Now see, there is one here. 81 is section 80. Now, explanation is added. It is defining what proper custody is. Proper custody in simple terms. If someone has the custody of some record, which he would usually have officially, then it is said to be in proper custody. Same thing applies to section 80 and same thing applies to section 81. The next section which talks about this thing, electronic records. And also there have been, just very interesting thing, when this Bharatiya Sakshi Adhiniyam was discussed before the Parliamentary Standing Committee, there were discussions. Like the courts are saying that you mentioned the hash value, but it is coming into effect when it is being brought to the notice of the court. What about situations before that? Because that is the stage wherein tampering can happen, right? So the Bharatiya Nagrik Suraksha Sanhita, there is a provision made that while filing the police report, if there is electronic evidence available, then police shall mention the chain of custody, that who all had the custody of these electronic records. This is their new addition. This was not there earlier in the Bharatiya Nagrik Suraksha Sanhita now. Again, see section 81, proper custody for electronic records. Section 82 has been removed from BSA. It is talking about England again, so removed. Digital signature, new addition, same thing. Again, Indianized.
Sir, if sorry to interrupt, sir, if you will permit, then we will proceed for lunch break. After that, it will continue.
Okay, fine, sir, fine, we can do that, right. Thank you.
Okay. We will continue where we have left. and we will continue on evidence set. And later on, you cover the other part which you have required to cover.
Right, sir. Right, sir. Thank you.
Okay, by all the respected participants, we will proceed for lunch break for 1 hour, that is from 1:30 to 2:20 for 50 minutes, and after that we will continue, resume our session at 2:20. Thank you. We will start our session from 2:20 onward. Thank you.
is defined proper custody. Now the definition, the explanation is only added to section 80 at one place, and the rest of the places only reference to section 80 has been given. So this term proper custody has been defined only at one place, and other places it is this only. And a reference is given, and it simply means that proper custody is a person who is in charge of something which is in his custody. As a general rule, they should have the custody. Then proper custody is said to have been maintained. At the same time, there may also be an issue whether the custody was proper or not. To find out the origin of the document or the record, then this issue of proper custody does not matter much. That is also mentioned in the explanation itself. Right. So, next thing is section 90A. Same thing. Explanation was there, proper custody, that has been removed now, and explanation given in section 81 would follow because it is for electronic records. Now you see there is no change in the sections. Section 91 to 100 as it was there, they are same, 94 to section 103. Only section numbers have been changed, or they have been renumbered. That is it. Other than this, there is no change. Reference to section 113. 113 has been removed from Bharatiya Sakshi Adhiniyam, proof of cession of territory. It was not required now. Then this thing, you see section 120, the heading has been changed. The content is same, parties to civil suit and their wives or husbands. This was the case. Now competency of husband and wife as witness in certain cases. This has been properly explained, nothing more than that. The concept and the content both are same. And then judgments, a list of judgments I have mentioned, that there is no inflexible rule that if a party gives his testimony, he must be disbelieved because he is a party to the suit. It is not the case. These are competent parties, competent witnesses are there, then testimonies may be allowed. Now you see again, 121 to 127, there is no change. It's just that 132, जो आपका section 126 or 127 था, which talks about professional communication, that any communication between a lawyer and a client shall not be disclosed, like that. Same thing applies to the translator also, right? So these two sections have been merged to section 132, and subsection 3 has been added after illustrations. इसमें एक इशू है, अगर आप देखेंगे क्लरिकल एरर है इसके अंदर. अगर आपके पास बेयर एक्ट्स हो तो आप देखेंगे जनरली व्हाट हैपेंस इज there are subsections mentioned and then you have the illustrations, right? In this section what has happened, there are illustrations and then there is subsection 3. So maybe this is a clerical error, they will remove it later on. Then you may see next section, again 120, it has reference to barrister, pleader, again, vakil, etc. that has been removed. Advocate has been used, there is no change. Examination in chief. Now section 137 has been amended a little bit, but content is not changed. The headings have been removed. It is now restructured in the form of simple subsections. That's it. Other things have not been changed. Now there are two judgments that I mentioned here. I just came across these judgments that, see, we all understand that we have an adversarial system and there is a rule of fair justice, fair trial, that all the parties should be heard. And when a party is being heard, the adverse party should be given the right to cross-examine him. In cases if cross-examination ka right is denied, that is that would not be just. And this is what judgment says, that when the opportunity to the adverse party of cross-examination is not given, the evidence is liable to be rejected as hearsay. Right, and then you see there is one more judgment that it was held that some time should intervene between framing of charges and statement of the accused about his desire of cross-examination, because in large number of cases they are ignorant of the law and must need advice before they can make up their mind whether further cross-examine whether to further cross-examine the witness already examined by the prosecution or not. Right. At the same time, you see one more judgment I came across. This is a recent judgment, Mukesh Singh versus State of Uttar Pradesh. The chief examination and cross-examination of witness must be recorded the same day or the following day. So Supreme Court is in form of giving a directive to the courts that chief and cross should preferably be done on the same day, or if it could not be done for certain reasons, then it may be postponed to the next day. But it should be done at the earliest. Then you will see Rajesh Yadav versus State of UP, 22 judgment again. The trial court should take up the examination of private witnesses first before proceeding with that of the official witness. So again, just a kind of directive coming from Supreme Court. Then this thing, section 138 has been now section 143, and a subheading, direction of re-examination, that has been removed now. This red ink highlights removable. Okay, so this has been removed and it has been merged to section 143 itself in the form of subsections. When there is a judgment, list of judgments I have given, you may see that a witness summoned merely to produce a document does not become a witness for purpose of cross-examination, since he may either attend the court personally or may depute any person to produce the document. This is about the directive as to but the sequence of witness, the direction of witness, when they should be examined, and who qualify as a witness. Right. Then you will see section 141, 142 and 3. They have been merged into one section, that is 146 now. And the headings, when they must be asked, when they may not be asked, that is removed. So in simple terms, leading questions are now in section 146 only. And the procedure as it was existing shall follow. There is no change in it. So there's one judgment that I came across which states that a general order that no leading questions shall be asked in cross-examination, the order is illegal and vitiates the trial. Right, because in cross-examination, leading questions are allowed. So contrarily, the courts are coming up with the same view. Now see, the section 166, power of jury or assessors to put questions has been removed. There is no parallel section in the Bharatiya Saksha Adhiniyam, and that is all with respect to the Bharatiya Saksha Adhiniyam. And I'll share this new slide also, wherein I have just added some case laws, and you may just go through these things. Now I'll start with the other topics, the second session that was given to me.
Please, sir, you can start.
Yes, 1 second. Sure. Right. So the other topic that I am assigned today is the provisions relating to cognizance till the commencement of trial. Right. So there have been few changes in the Bharatiya Nagrik Suraksha Sahita. You all, I am sure, have gone through a series of sessions wherein no comparative studies have been done that these are the changes and these are the implications. I'll be talking about majorly cognizance till the stage of commencement of trial. That is charge and discharge. That's it. Cognizance, you all know that as it was there in section 190, that has been now shifted to section 210 of bnss. Let me come to this slide. Though there has been some changes, some slight modifications have been brought herein. The complaint as it was defined in section 2D of CRPC, that is now section 21H of BNSS, and complaint is, you all know, that mentioning the grievance and then what action you want and addressing it to the court, to the magistrate. You all know that section 173 has been there in BNSS, which was earlier section 154 about FIR. So FIR it has been now simply clarified that FIR may be either lodged in the by going physically to the police station or through online format. So format is not prescribed under BNSS, but it is allowing lodging of an online FIR. So that could be through several mechanisms or several platforms like even a a WhatsApp or a phone call or any website or any other social media, that no, and again, power is given to the state government to come up with rules, like what format would be counted or allowed therein, right? So same thing is there, like if a police officer refuses to lodge an FIR, the person can go to the SP, write a letter to the SP. Now, one addition, if you would have seen that provision, it mentions that failing which a person may approach to the magistrate. This line has been added, newly added under section 173, and which signifies that first person has to exercise the options available, that is lodging of the FIR, going to the police, going to the superintendent of police, and if these things do not work out, then they may approach the magistrate for the purpose of taking cognizance. And cognizance, in simple terms, you all know it is being apprised to, no, applying judicial mind to take action, and all these things are there, applicable. So for the same reason, section 210, which empowers the magistrate to take cognizance, it mentions that upon a complaint, receiving of a complaint of facts, including any complaint filed by a person authorized by any special law, which constitutes an offense, then upon a police report submitted in any mode, including electronic mode. If you also remember that BNSS makes a new change, that every police report is to be now filed in electronic format also, in soft copy, in digital form. That means police should be filing the hard copy as well as the soft copy. And then later on it is clarified that these soft copies may be used by the court for the purpose of giving it to the accused person. Right? So in this manner the work is simplified. Now the BNSS has allowed presently both the things. Hard copy need to be filed as well as soft copy need to be filed by the police. At the same time, it might happen in future that hard copy may not be required, right? So you see that it says upon a police report submitted in any mode, including electronic mode. So this suggests that कि पुलिस द्वारा किसी भी फॉर्मेट में फाइल किया जा सकता है, हार्ड कॉपी में भी, सॉफ्ट कॉपी में भी. But if you compare it, section 193 of BNSS, it says including electronic format. So वहां पे तो कह रहा है कि दोनों फॉर्मेट में फाइल करना है, बट ऐसा हो सकता है कि फ्यूचर में ये आप सिर्फ इलेक्ट्रॉनिक फॉर्म में शिफ्ट हो जाएं. एंड मैजिस्ट्रेट्स हैव द पावर टू डू बोथ द थिंग्स. They may take cognizance on the hard copy as well as on the soft copy, or either of the two, right? And third is upon information received from any person other than the police officer, that is suo motu cognizance. So these three things are there which were existing. Just new addition that electronic format has been allowed. Right. Now moving on to the next slide, you see. You all know powers of magistrates are there, that police may come up with an opinion that they want to drop the charges against the accused, so no case is committed or evidence is found deficient. Magistrates have the power to take cognizance even on that basis also. So even if the police is concluding that there is no case made out, there is deficiency in any kind of evidence, and even then the magistrates have the power to take cognizance, and vice versa also. Police may conclude that the case is made out, magistrate has the power not to take the cognizance. That means court is not bound by the opinion expressed by the police in the police report, in simple terms, right? And see, the same thing I have mentioned, these series of judgments which have come here. Then moving on to next section, 211 is there. This is this is in respect to section 210 subclause C, which talks about suo motu cognizance. So it's simply asking the court to inform the person wherein suo motu cognizance has been taken, that you have right for the transfer of case to the other court, that case be tried by the other court. In simple terms, reason being, since the magistrate has taken suo motu cognizance, he is either the complainant or he becomes aggrieved. So a person who is aggrieved or a person who is a complainant cannot be a judge in his own case. So this is the principle of natural justice only. So section 211 was there, and it has not been touched by the parliamentary committee. It is same as it is, right? But this information should be given to the the person who is arrested, who is on trial. And there have been judgments wherein the courts have said, if on information to the person makes a a request for the transfer of case, and if that request is rejected, then it is an illegality. It would not be an irregularity, it is an illegality when a request has been made for transfer and the courts reject it. So in such cases, requests should be allowed. So you see, under section 465 of CRPC, we had provision for irregularity and all. Now that has been moved to section 511, and it says refusal of accused person's request for transfer in such case would be illegal, which cannot be cured under section 511 of the BNSS. Right. Now you see section 212 is there. It is not changed. It is same as it was. Making over of cases to magistrates. There's one judgment I mentioned. This thing. Court of session. They are not declared to be the court of first instance. They cannot take cognizance. The case has to be committed to the court of session by the magistrate only. This is the settled rule. But there may be special laws enacted which may empower the sessions court to take cognizance as a court of original jurisdiction. But that power needs to be mentioned, or it should be coming from a special statute itself. Let's say SC/ST Act is there, which empowers the court to take direct cognizance. Otherwise, if there is no statute, that can't happen. At the same time, at this point, I just want to mention also, there have been series of judgments wherein the courts have committed blunder, which need to be corrected. If you would be aware of the Juvenile Justice 2015, Juvenile Justice Act says that in every case wherein a heinous offence is committed by a person between 16 to 18 years of age, then a preliminary assessment is conducted. And that preliminary assessment is mandatorily conducted by the JJB only, right? And if during that preliminary assessment, wherein the physical capacity, the mental capacity, and the circumstances of committing the crime, all this is checked, court comes to the finding that the child is fit to be tried as an adult, then case is transferred to the children's court. Children's court is the sessions court. I have come across several cases wherein sessions court has taken so much cognizance in such cases and conducted preliminary assessment on its own, and citing the reason that since anyway the case has to be come to them only by the JJB, so they are empowered to do it. And these judgments have been struck down by the Supreme Court, saying that the JJ Act clearly mentions that preliminary assessment is the domain of JJB. Even Supreme Court do not conduct preliminary assessment. They transfer the case to JJB for conducting preliminary assessment. So children's court, which are the sessions courts only, they cannot conduct preliminary assessment. They have to wait for the order from the JJB itself. And there have been cases wherein police, see, these things have arisen because either the case was wrongfully committed by the judicial magistrate. So judicial magistrate who were subordinate, they wrongfully committed the case to the sessions court, despite knowing the fact that the person is a child. And there have been cases wherein on the date of commission of the sessions court, the child was around 12 years of age. So 12 साल का बच्चा तो by appearance only he would look as a child. So these things should be carefully done so that later on this embarrassment which comes from Supreme Court should not happen, right? So sessions court, they are not allowed to take cognizance unless expressly authorized by a special statute. Recently, Supreme Court also in this judgment, AMCS Swami versus Mehndi Aga Karbalai, mentioned that so special court can take cognizance of an offence without committal if the special act empowers it. So the act has to empower it. Now section 214, additional sessions judges to try cases made over to them. This is same. And this committal of case is an administrative work. So there is this is what Supreme Court again recognized in this M. Palani State in 2023 also. One new change is there in section 215 that talks about the prosecution of contempt of lawful authority. Now this only clarifies one more thing, like no cognizance shall take place of the contempt of lawful authority except when on a complaint in writing of the public servant, this is one point, to some other public servant to whom he is subordinate, administratively subordinate. This was there earlier. Now it says, or some other public servant who is authorized by the concerned public servant so to do. So this is just an explanation कि अगर किसी को authorize किया गया है इसके लिए, that person can also file the complaint. So the ambit has been now broadened, widened. You see, there is one judgment, Ramesh Mandola versus State of Madhya Pradesh, 2022 judgment. Section 215 in the opening line says no court shall take cognizance. So it's just a prohibition for the courts to take cognizance. This does not bar the lodging of an FIR. FIR may still be lodged because that is not prohibited. It only prohibits taking of cognizance. Right? So the same thing was held in this Ramesh Mandola versus State of Madhya Pradesh also recently in 22. And prosecution of judges and public servants. Now there has been some change around this provision. You see, if you remember section this thing in the bnss only, lodging of an FIR, that courts shall not take cognizance against a public servant unless the public servant has been heard, the complainant has been examined on affidavit, the police officer has been heard, all these things are done, and report of officer who is superior to the person against whom a complaint has been made, all these things should be done. That is now a new concept, pre-trial hearing or pre-cognizance hearing is there. Right, so before taking cognizance, court should examine the accused public servant. His opinion should be taken into consideration. Then report of the superior of that public servant, that is to be considered. And then there has to be a sanction for the purpose of this thing, prosecution. This is a new addition here now, that where an application for sanction has been made, the government has to decide upon the application within 120 days of the receiving of the application. 120 days के अंदर आपको decision लेना होगा कि sanction दिया जाना है कि sanction नहीं दिया जाना है, and if the government fails to do so, it will be presumed that the permission has been given. So there is a presumption in favor of the giving of the permission for the purpose of prosecution. So this is a new addition. Otherwise, no sanction will be required for sexual offences, which are mentioned in section 64, 65, 6, 8, etc. of Bharatiya Nyaya Sanhita. Right. Then there is one more judgment from 2020. Question that may come before the court of law, that whether the act which is purported to be prosecuted, whether it is part of the discharge of the official duty or not. Because see, section this thing 218 is protecting only those acts which are done or executed in the discharge of the official duty. You may see this third line, an offence alleged to have been committed by him while acting or purporting to act in the discharge of his official duty. Right. So there may be issues that whether the act which is alleged to be an offence, whether it is done in the discharge of official duty or not. So court in the judgment gave a broader view and said that even acts which are strictly not part of the official duty, but in excess of the exercise of the powers, right? Even if some officer has exceeded in the exercise of the power, even that would be protected within section 218, because that would be covered within the term purported to be done in exercise of the official duty, right? So this is one thing. Then 219, which is about prosecution for offences against marriage. The content is subsection 1 is same. Subsection 2, there is slight change. And this provision has been now narrowed down instead of being widened. It says that the husband of the woman is said to be grieved person primarily. And earlier is also used to mention wherein a person has the care and custody of the woman, that person can also complain. Now that has been removed from BNSS. Only husband has been mentioned here, subsection 2. Second thing that is changed in subsection 3, that the term lunacy has been replaced with the term unsoundness of mind. Right. So earlier it was lunacy, now unsoundness of mind, because you all know unsoundness of mind is a neutral term. Lunacy might have some kind of restrictions attached to it. Unsoundness of mind is legally tested across all judgments, across all provisions. So it is changed. Right. And this term child is used. Earlier it was a person below 18 years of age. So JJ Act defines child as below 18 years of age. So that definition is now becoming the general pattern everywhere. So that term child, neutral term is there, child is mentioned. Now you see prosecution for defamation, same change has been brought here. Also, child, person of unsoundness of mind, unsound mind, or having intellectual disability. Having intellectual disability, I believe, was not required here, because initially they are using child and unsoundness of mind. Unsoundness of mind might also cover within its ambit intellectual disability, because intellectual disability does not have any parameters listed here. So it can again open Pandora box. What would qualify, what would not qualify. So I believe child of or unsoundness of mind would have sufficed this provision. But it is there now. You see that again, there is one case that a private complaint can be filed by the public servant apart from the procedure followed under 199 as it was in आपका CRPC में जो था. So there is prosecution for defamation, 222 is there. So instead of following this entire procedure, a private complaint may also be filed in the private capacity. So every public servant has private capacity as well as the official capacity. For the same thing, this judgment has come from Supreme Court only. Then complaints to magistrate. Yes, examination of complaint. This is pre-trial this hearing in complaint cases. It is simply saying that provided that no cognizance of an offence shall be taken by a magistrate without giving the accused an opportunity of being heard. So in simple terms, in every case where a complaint is being filed, you have to conduct a hearing of the accused person against whom a private complaint has been filed before the magistrate. And courts cannot take cognizance unless the accused has been examined. Right? So I believe for the same reason, the provision relating to lodging of an FIR has been amended, and it clearly mentions failing which. That means if a person is filing a complaint before the magistrate may direct that complainant to first go and exercise the provisions which are there, approaching the police, lodging of the FIR and XYZ things, and then if those things do not work out, then only come to the court for filing of the complaint. Now, this thing, again a new addition for preventing filing of false cases, that a magistrate shall not take cognizance on a complaint against a public servant for any offence alleged to have been committed in course of the discharge of his official functions or duties unless two things are satisfied. Right? Such public servant is given an opportunity to make assertions as to the situation that led to the incident, and 2, the report containing facts and circumstances of the incident from the officer superior to such public servant. Right? So if you compare this section to as it was there in 1563 of CRPC, that is, I believe, now 175. So that mentions now that magistrate cannot order investigation. Subsection 4 mentions there that magistrate cannot order investigation against a public servant unless the requirements have been complied with. Right? इधर पे क्या कहना चाह रहे हैं? इधर पे ये कहना चाह रहे हैं that magistrates cannot take cognizance against a public servant unless these two conditions are satisfied. That is, a report from the superior of the public servant, and second is hearing of the public servant. He should be allowed to give his version first before taking cognizance. right? Then there is the judgment coming from Supreme Court in 2024 only, Mukhtar Zaidi versus State of Uttar Pradesh. The rejection of protest petition is no bar to file fresh complaint under Section 200. Now, this thing was there, if you compare it with the provisions relating to investigation, and there have been judgments coming from courts. Like there is judgment from Bihar High Court only, I believe. This Pancham versus State of Bihar, which says that wherein the aggrieved is not happy from the police report, that the person may file a protest petition, and that protest petition may be, obviously, there are judgments which says that protest petitions may be considered as a complaint, right? So same thing is reflecting in the Mukhtar Zaidi versus State of Uttar Pradesh judgment, that a person who is aggrieved from the police report may obviously file a protest petition, and those protest petitions may be taken into consideration as a complaint. And if a protest petition has been rejected, then obviously a fresh complaint may also be filed. So rejection of the protest petition does not act as a bar for filing of the a complaint before a magistrate. The issue of process, some changes here also. You remember that provisions relating to warrants and summons have been changed a little bit. That electronic summons may be now passed and they may be delivered electronically. And the registrar of the court and the police station SHOs, they have been directed to maintain register that shall contain the name and the address and the phone number and the email ID of people. Right, and someone delivered electronically is sufficient proof of the delivery of the summons. The same thing is mentioned here also, that summons or warrants may also be issued through electronic means. So it is an empowering provision for the court to issue summons and warrants in the electronic means. But at the same time, warrants can't be executed electronically. Summons may be executed electronically also. So that distinction is to be understood. And rest provision is same. Then Amit Kumar is the state of UP, again 24 judgment. Court is just trying to highlight the ambit of prima facie satisfaction of the magistrate. So magistrates needs to be convinced that there is a prima facie case made out, and then respective orders may be passed. This 228, talking about the dispensation of personal attendance. Again, either pe yahan pe reference was given to barrister and all, so that has been replaced with the term advocate. So everywhere it is done in the same manner. It's again Sharif Ahmed versus State of Uttar Pradesh 24 judgment is there. And before the grant of bail, accused can be exempted from showing his personal appearance before the court. So this order, that personal appearance may be dispensed with, this order may be passed even before the grant of bail. Again, see 229 is there. Everywhere, advocate has been used, pleader and all, that has been removed. And one more change is there. Provided that the amount of fine specified in such summons shall not exceed 5,000 rupees. So this was earlier 3,000 rupees. That has been now increased to 5,000 rupees. And otherwise there is no change. And here also see subsection 2, this 5,000 rupees has been mentioned instead of 3,000. Now see section 230 is there, supply of to the accused of copy of police report. Now, one addition is there, that this supply of copies should be done mandatorily within 14 days from the date of production or appearance of the accused. Accused के appearance होने के 14 दिनों के अंदर, 14 days के अंदर आपको ये supply ensure करनी है to the accused as well as also the victim. If the victim is represented by an advocate, then obviously victim का advocate को आप सप्लाई करवाएंगे कॉपी. तो अभी दोनों पार्टीज को यहाँ पे देने की बात की गई है, ठीक है. एंड द डेडलाइन इज 14 days ओनली. one thing that needs to be again noticed here is, as I was referring to 193 of BNSS, that says the police filing the police report may file it in electronic form also, right? So same thing is mentioned here, that provided that the supply of documents in electronic form shall be considered as duly furnished. So this is sufficient compliance of the provision of 230. It is not necessary to supply to the accused person and the victim the hard copies. Only the soft copies supply would be considered as sufficient compliance. Now you see, this change that is brought there in BNSS is inspired by judgments coming from Supreme Court. Central Bureau of Investigation Bihar is Abhishek Sachan. It is a 23 judgment wherein the court is saying the supply of documents in digital format is permissible. So this thing is again copied into BNSS, and it is saying that you may submit it in the soft form, right? Then one clerical error I believe that is committed in drafting the statute. This is for the sessions trial, and the last line mentions that provided further that supply of documents in electronic form shall be considered as duly furnished. इधर पे दो चीजें मिस हो गई इनसे. एक पैराग्राफ था जो पुराने सेक्शन में था, आप देखेंगे यहाँ पे ये provided that if the magistrate is satisfied that any such document is voluminous, he shall, instead of furnishing the accused and the victim with a copy thereof, may furnish the copies through electronic means. So this is an enabling provision, right? And which is followed by the proviso. Now here you see that line is missing. Half section is copied, the remaining is missing. That direct that he will only be allowed to inspect it either personally or through an advocate in court. And after this, there was mention about victim and the supply of copies in electronic form. That is missing from this section. Though implication is same, because the last line clearly says that it may be supplied through in electronic form, right? That should be considered as duly furnished. But I believe this is just a clerical error. Commitment of case to Sessions Court of Session when offence is triable exclusively by it. There is one judgment just to highlight. The magistrate which is committing the case to the Sessions Court does not have power to discharge. It is for the Court of Session to which the case will be committed. Only that court will have the power to discharge the case in such cases, right? Otherwise, the provision is the same. Then provisos are added herein, exceptions are added, provided that proceeding under this section shall be completed within a period of 90 days from the date of taking cognizance, and such period may be extended by the magistrate for a period not exceeding 180 days for the reasons to be recorded in writing. Provided further that any application filed before magistrate by the accused or the victim or any person authorized by such person in a case triable by Court of Session shall also be forwarded to the Court of Session with the committal of the case. So this committal proceedings for the commitment to the Sessions Court shall be done within a period of 90 days, but which may be extended to 180 days with the permission, and reasons should be recorded. And also for the committal, if some application has been received by the magistrate that the case should be committed to the Sessions Court, that shall also be transferred along with the case to the Sessions Court. This is a new addition in section 232. Now, offences of same kind within year may be charged together. This was earlier 3. Now it has been increased to 5. That 5 offences of same kind may be committed in 12 months may be charged together and tried together. And then discharge. This is a common change that has been brought here and other places also. that accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under 232. So let's say magistrate took a cognizance, then magistrate got to know that the case is triable exclusively by a court of session. The committal would be done within 90 days. Case came to the sessions court. Now, before sessions court, this person who is aggrieved may file an application within 60 days for discharge. So, it is fixing a timeline within which this application for discharge shall be moved. However, the BNSS nowhere mentions what would be the implications of not filing an application of discharge. Though it is saying 60 दिनों में आपको discharge application file करनी है before the court, but it nowhere mentions what would be the consequence, what would be the repercussions if someone fails to file the application for discharge within 60 days, right? Then you see framing of charges again. Clause B mentions that it excludes by the court, he shall frame a charge in writing against the accused within a period of 60 days from the date of first hearing. Right. So again, a timeline has been mentioned that court framing charges shall frame it within 60 days from the first date of hearing. Right. You all know that there is a certain protocol attached to it. That filing of this thing, framing of the charges and reading over of the charges to the accused person, explaining him the details and the intricacies of the charges. So that could now be done either electronically or through physical mode, both, right? So it is allowing audio video conferencing also for the purpose of these proceedings. So it is not now necessary to bring the arrested person or the accused person to the court at the time of framing of charges. So this could also be done through audio video electronic means. This case is there from 24 judgment, Letty Thomas's state of Kerala. Before framing charges under 228 of CRPC, a judge has to form an opinion that there is ground for presuming that an accused has committed an offence. This is general guideline coming from Supreme Court, and there are a series of judgments on this point. Trial of warrant cases by magistrate now. 261 is same, there is no change. Yes. Again, magistrate के पास जब trial हो रहा है, the accused again has to prefer an application for discharge within 60 days from the date of supply of the copies of documents under 230. So जिस तारीख को document supply किए गए हैं section 230 के अंदर, from that date 60 days shall be counted. Right, but again, no provision has been made about what would be the implications and result of not filing of the application for discharge. Right, then again, as there is some judgment, Ajay Kumar Ghosh versus State of Jharkhand. The magistrate has to consider the police report and the documents sent with it under section 173. I'm talking about CRPC, and if necessary, has to examine the accused and has to hear the prosecution of the accused. And if on such examination and hearing, the magistrate considers the charge to be groundless, he would discharge the accused and record his reasons for so doing. Right? Now you see again a timeline has been fixed here for framing of charges, that within 60 days from the first date of hearing, charges shall be framed. Right? So जहाँ पे discharge application है, वहां पे 60 days काउंट होगा सप्लाई ऑफ डॉक्यूमेंट से. जहां पे फ्रेमिंग ऑफ चार्जेस के 60 days हैं, दैट शैल बी काउंटेड फ्रॉम द डेट ऑफ फर्स्ट हियरिंग. सो दिस डिस्टिंक्शन शुड बी अंडरस्टूड. Then again one judgment I have mentioned, that proceeding under 240 of CRPC culminate in an order framing of charge only after the plea of the accused is taken as per subsection 2 of section 240. This is again a directive coming from Kerala High Court. And see, this absence of complainant and section 270, this is again a new addition, that when the proceedings have been instituted upon a complaint and on any day fix for hearing of the case, the complainant is absent and the offence may be lawfully compounded or is not a cognizable offence. In दो category के cases में complainant is absent, and then either offence is compoundable or it is a non-cognizable offence, then magistrate may, after giving 30 days time to the complainant to appear, may in his discretion discharge. Right? So 30 दिन का समय देगा complainant को that you have to appear and answer, and if the complainant fails to appear, then magistrate may in his discretion discharge the accused person. This 30 days time was not there in the CRPC. This is the new addition. The limitation, you may see that for the purposes of computing the period of limitation, the relevant date shall be the date of filing complaint under 223 or the date of recording of information under 173. Right. So this explanation should be is relevant for us. And then lastly, reckoning date for limitation is the date of filing of the final report, not the registration of FIR. This is coming from a Madras High Court judgment, that is the contrary view expressed as given in the explanation. Reason being, this judgment is coming under the earlier law, and this explanation is given in the new law, right? So in simple terms, the period of limitation shall be counted in complaint cases from the date of filing of the complaint, and in other cases where FIR is filed, from the date of the lodging of the FIR, it shall be counted. And that is all from my side. These are the only provisions that I had to deal with. If there are any questions, we may discuss. If there are any other points, we may discuss about it. No questions?
If any questions, please ask.
Okay, thank you. I believe there are no questions.
Sir, one minute. If just summarizing what sir has submitted regarding Evidence Act, sir has clearly said that there is no change in the provisions. Basically, in Evidence Act, Bharatiya Sakshya Adhiniyam, there is no fundamental changes from Evidence Act to Bharatiya Sakshya Adhiniyam. Mostly the provisions are reformulated and recollected and rearranged. But the electronic form of evidence, electronic form of document has been defined, and regarding electronic evidence, changes has been made. As sir has said that confession chapter rearranged, confession before the police has been rearranged, 3 section has been togetherly rearranged, dying declaration portion rearranged, and colonial terms and phrases has been deleted from this new Bharatiya Sakshya Adhiniyam. Expert evidence has been widened, and expert of any field has been incorporated instead of expert of certain field which is illustrative in nature. Forms has been attached in schedule regarding providing electronic evidence, Form A and Form B, which is required to be considered by the judicial officers. So, what is important in Bharatiya Sakshya Adhiniyam is that to consider the electronic evidence, electronic document and its interpretation in wider form, as we are going to flooded with electronic form of documents and evidences in the court during trial. So, it is required to be understand and think over for the judicial officer to for the trial of the cases from 1 July onward. And if we summarize the bnss which sir has submitted and earlier speaker has submitted, we can summarize it as under that definition section has been widened. Audio visual electronic means bail, bail bond and victim has been redefined and defined it in some different nomenclature. Like bail bond means bond with surety, Bond means personal bond. It has been mentioned in the BNSS. Then monetary jurisdiction of first class magistrate and second class magistrate has been enhanced. After that, concept of zero FIR, E-FIR and its modalities has been mentioned. Copy of FIR has also been provided to the victim apart from its maker. Provision of handcuffing has been legalized in certain grave offences, which is illustrative in nature. Medical report which is required to be furnished by the medical expert during investigation, the time limit has been prescribed, that is 14 days, and it should be provided within 14 days. Role of forensic science and forensic expert has been enhanced, and investigation must be followed with forensic expert and its evidence, so that make the evidence more truthful, impartial and effective. Duration of police remand, which is at present is for 50 days in both the cases, both the nature of cases, is now increased up to 40 days, where the investigation has to conclude within 60 days, and 60 days where the investigation has to be concluded within 90 days. Thereafter, pre-cognizance hearing of the accused is also incorporated. Investigation of the police in cases of rape must be complete within 2 months. That is, provision of the POCSO Act is included in this act. Victim right. The victim has a right, and having duly informed regarding progress of trial and investigation within 90 days by the police officials. A provision of bail is also explained, and all the judgment which is recently pronounced by the Honorable High Court has been incorporated, and provision regarding first offender, bail regarding first offender has been relaxed. Provision of deemed sanction has been also incorporated in cases where sanction is required for proceed against public officials or public servants, and if in 120 days a sanction is not received, then it is deemed that the sanction has been given by the state. The sanction is accorded accordingly. Committal of case time limit has been provided, and that committal must be met within 60 days from date of cognizance, or maximum within 180 days. Discharge application in sessions trial is also time bound, that is within 60 days from date of committal, and the charge is also must be framed within 60 days from date of first hearing, as far as submitted. The changes has been made in BNSS. A timeline for judgment is also mentioned, that is on conclusion of argument, the judgment should be pronounced within 30 days and with reason within 45 days. It means that within 45 days you have to pronounce the judgment where the argument is concluded. The jurisdiction of summary trial proceedings has been also enhanced, that is 2,000 to 20,000, punishment from 2 years to 3 years. Summary trial could be done in those cases. Audio video recording of search and seizure is must, and the report of audio video recording must be forwarded to concerned magistrate within 24 hours. Schedule 2 of BNSS is also changed accordingly by mentioning the time period and time limit. Timeline for filing of application of plea bargaining is also fixed. Witness protection scheme has been incorporated in BNSS. In case of withdrawal of cases by prosecution, hearing of the victim is also required. Trial in absentia is validated, mainly in the cases where the accused is absconding. The trial in his absentia is validated. Timeline has been prescribed for mercy petition also. Timeline has been prescribed for mercy petition and other petitions also. The scope of commutation has been redefined and limited by clear expression in the Sanghita. Police report will be filed in hand copy as well as in electronic copy, that is soft copy. Instead of lunacy, the term of unsoundness of mind has been used at several places. In complaint cases, cognizance could be taken after hearing of the accused. That is the new provision which is incorporated. A complaint against police servant could be maintained, and cognizance could be taken only after hearing him and calling a report from his higher officials. Summons and warrant cases, warrant can be issued in electronic form and means. Summon for petty offences, monetary limit has been enhanced, that is from 3,000 to 5,000. Copy of police paper must be provided to the victim also, along with accused, and it may be also provided within in electronic form, and the time limit is 14 days. 5 offences committed within same years of same nature could be tried together. That is, chapter related to charge framing has been amended accordingly. Framing of charge, as I have said, in warrant tribal cases also could be done within 60 days from first hearing. So these are the changes which is incorporated. I have tried my best to summarize it, and sir has explained not only the evidence head and the BNSS with examples as well as case laws to guide us effectively and work efficiently. So I owe my deep sense of gratitude, sir, for kind acceptance our request to address both these topics, and I wish and will request that sir will also spare time in future to address all of us. And I think the material which is provided by the sir will be circulated among the judicial officers so that they can use it further in their work and to adjudicate the matter efficiently and effectively in the light and spirit of the newly enacted criminal law, that is BNSS and Bharatiya Nyaya Sanhita and Bharatiya Saksh Adhiniyam. Thank you. Thanks a lot. Thank you. Thank you, sir. Thanks a lot.
Thank you, sir. Thank
We
you.
will resume our session within 5 minutes with another speaker. Within 5 minutes, we will resume. Thank you. ये सर को देखना चाह रहे, ये वीडियो उनका देखो तो नहीं आ रहा है सर, वीडियो नहीं आ रहा आपका?
Sir, good afternoon.
yes, visible now.
Video, sir.
We will start.
Sir,
हम शुरू करें सर?
should I share the Bare Act on the screen or is it available with the participants? Judges के साथ.
Here it is available with the. You can share also, sir. It's very good.
Okay, sir. If it is available, then it is just for reference, so I can stop this.
Okay. Okay.
Okay, sir. Thank you.
Good afternoon to one and all. We are now in the last session of our today's program, and it will be addressed by Sri Anubhav Kumar, Assistant Professor Law, National Law University, Patiala, Punjab. And Sir is in the research team of this new legislation, and as expert on these laws, this new law, that is Bharatiya Nyaya Sanhita, Sakshi Sanhita, and to train all the officials related with these laws. And today, sir is going to address the changes incorporated to Bharatiya Nyaya Sanhita regarding offences affecting to the human body in detail. Now over to sir.
Thank you so much, sir, for introducing me and inviting me for this session. My respect to Double Director, sir, the officers of the Bihar Judicial Academy, and respected participant judges for this session. Just to give at the very outset, just to give an idea of what I believe I have expressed in my previous session, because to my knowledge, it was also available or shared with all the participants or all the participant judges in the Bihar Judicial Service. So this particular session, as has been mentioned by sir as well, that it is dedicated to one part of the Bharatiya Nyaya Sanhita, and it is a dedicated kind of session. So we are going to discuss a specific topic today, specific section or specific part of the BNS today, and that is offences related to body. And that is how I am personally trying to focus upon a particular aspect or an area as to what all changes have been introduced, and not just changes, but what are the core concepts which are involved in these kind of offences. So it is a step forward to understand, maybe just gradually we are learning the new things and unlearning to some extent the older provisions, because we need to now understand what section 100 of the BNS means, what section 101 is, what 102 is. So we need to also learn and to remember it every time when we refer to provisions like in which section murder is there, in which section the punishment for murder is there, or culpable homicide is there. So just an attempt towards this particular aspect of law, that how the new offences have been placed in the specific chapter of offences against people. To start with this, let me reiterate this particular fact that the offences against body chapter has now been divided, which was earlier there under the Indian Penal Code, has now been divided, and offences against women and offences against children have been culled out from the chapter of offences against human body, and they have been placed in a separate chapter, that is chapter 5 of the Bharatiya Nyaya Sanhita. The object and purpose of this, as has been stated also by the different platforms, the purpose is to give more importance now to those offences, to re-emphasize on those offences which are committed against women and children, so that they come early in the Bharatiya Nyaya Sanhita, and an emphasis can be laid down on these offences, and they can also be together if they are scattered in different sections or different parts of the standard criminal law. So that is another reason or purpose for it. Yet another reason is the reason that these offences are not offences against a body person. As in, an offence against a child is has a larger picture, has a larger connotation, has a larger meaning attached. It is not just an offense against body, it is an offense against children or the child. An offense against women is not just an offense against body, but it is also an offense against the dignity of the woman per se. So these offenses have been cut down. That is the very first point which I made. Second point is that this specific chapter which deals with offenses against body starts with section 100 and goes up to section 146. So precisely we have 46 to 47 provisions which are dealing with offenses against the body. So the number of provisions to some extent has been reduced, or we can in other words say it is consolidated. तो अगर हम बात कर रहे हैं इस पर्टिकुलर चैप्टर की, चैप्टर 6 जो ऑफेंसेस अगेंस्ट बॉडी है, चैप्टर 6 जो कि सेक्शन 100 से चलकर सेक्शन 146 तक है, वो एक कंसोलिडेटेड फॉर्म में है जो सिर्फ और सिर्फ ऑफेंसेस अगेंस्ट बॉडी की बात, पहली बात। दूसरी बात, इसमें कुछ नए ऑफेंसेस भी इंट्रोड्यूस किए गए हैं जो कि एग्जैक्टली ऑफेंसेस अगेंस्ट बॉडी के नेचर के नहीं है, लेकिन इनको कैटेगराइज किया गया है ऑफेंसेस अगेंस्ट बॉडी के अंतर्गत ही, जैसे फॉर एग्जांपल अ टेररिस्ट अटैक और एन ऑर्गेनाइज्ड। So basically these have a different connotation, as in they are mostly considered as a socio-economic offense in certain cases, or they are considered as an offense against the state in a larger perspective. लेकिन इनको भी उनमें से कई सारे एक्ट्स जो हैं वो बॉडीली ऑफेंसेस से रिलेटेड है, इसलिए इनको भी साथ में कैटेगराइज किया गया है, ऑफेंसेस अगेंस्ट बॉडी के अंतर्गत ही रखा गया है, यानी ऑर्गेनाइज्ड क्राइम और टेररिस्ट एक्ट। ऑर्गेनाइज्ड क्राइम कहने का मतलब ऑर्गेनाइज्ड क्राइम एंड पेटी ऑर्गेनाइज्ड क्राइम, जो दो स्पेसिफिक ऑफेंसेस हम देखेंगे आज इस सेशन में। तो 100 से अगर हम शुरुआत करें, एंड आई वुड लाइक योर kind attention on the provisions of the E-FIR Act. I'm not sharing it on the screen because you already must be having the E-FIR Act with you, the new E-FIR Act, and we'll take you through the provision today. Today my scheme of discussion would be provision wise, section wise, कि अब नया section 100, section 101, 102, 103 onwards up to 146, ये जो set of provision है offenses against body में, हर section क्या है, और इससे हमें clarity होगी इस बारे में कि अब अगर चार्ज फ्रेमिंग होती है तो मर्डर की जगह अब हमें कौन सा प्रोविजन, 302 की जगह अब चार्ज फ्रेमिंग में या पुलिस को भी या प्रोसिक्यूशन को भी वो कौन सा सेक्शन है जो रेफर करने की जरूरत हो, उसको अब हम ग्रेजुअली आत्मसात कर रहे हैं, और वही प्रयास मेरा इस पर्टिकुलर सेशन में। तो सेक्शन 100 से मेरी शुरुआत इस पर्टिकुलर सेशन की होगी, और हम सभी जानते हैं कि कल्पेबल होमिसाइड मर्डर वन ऑफ द मोस्ट सीरियस and in fact the most serious of the offenses against human body has also been categorized under the penal code. तो in the IPC में भी ये serious offense था, और वहीं से चैप्टर की शुरुआत होती थी। हम याद कर सकते हैं सेक्शन 299 को, जहां कल्पेबल होमिसाइड डिफाइंड था, और वही कल्पेबल होमिसाइड अब हमारे पास सेक्शन 200 में प्लेस किया गया है। In the new chapter, chapter 6, the first provision deals with the culpable homicide with exact definition and a change simply in the punishment aspect. So the definition of culpable homicide is one and the same. All the three mens rea, different forms of mens rea, basically two divided into three parts of the mens rea, that is based on intention or knowledge, is also similar as was there under the Indian penal. कहने का मतलब जो intention और knowledge पे based mens rea था culpable homicide का, that is the same under the भारतीय न्याय संहिता as well. So intention to cause, whoever causes death by doing an act with the intention of causing death, intention of causing bodily injury, or there is a likely to cause death, or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. So it is one and the same, and this understanding is basically available with all of us. The difference between culpable homicide and murder can be understood through landmark judgments of the Supreme Court. I would like to refer Virsa Singh versus State of Punjab, one of the landmark cases. The same would be applicable again here in Bharatiya Nyaya Sanhita, because there is no change as far as the difference in culpable homicide and murder is concerned. R versus Govinda की हम बात कर ले, the landmark judgment प्रिवी काउंसिल, और उसके बाद खास करके मेरा एम्फेसिस होगा इस डिफरेंशिएशन में पुनैया के केस पे, स्टेट वर्सेस आर पुनैया, जिसमें कोर्ट ने कल्पेबल होमिसाइड और मर्डर को डिफरेंशिएट किया है, काफी कैटेगोरिकली मेंशन किया है। विरसा सिंह में जैसे कि सेकेंडली और थर्डली को कंपेयर किया गया है मर्डर के सेकेंडली, थर्डली और फोर्थली से। So this kind of assessment is the same for the BNS as well, and we need to compare that in case of the culpable homicide not amounting to murder, it is a likelihood of causing death. However, in case of murder, the mens rea, the gravity, the mens rea increases depending upon the act which is manifested by such mens rea, and so there is a difference as discussed in the test or the objective or the subjective test, I would rather say, in Virsa Singh, that the subjectivity of the person who is doing or committing that particular act has to be. So this is that particular difference which we need to understand in case of culpable homicide and murder. So 100 deals with the definition of the offense of culpable homicide and the three explanations which are attached to the definition of culpable homicide. Moving on to the offense of murder 101, you will find the same definition again under murder 101 with 5 exceptions, the same 5 exceptions which were earlier under the Indian Penal Code, dealing with grave and sudden provocation or exceeding private defense or the exceeding the public servant exceeding rights, or if it is a sudden fight, or maybe death by consent. All those exceptions are one and the same. They are also mentioned under 101. So now section 300, which was earlier there defining murder, is now 101 of the BNS. So murder is 101. Murder is 101. Culpable homicide is 100. So 100, 101. Now, not going into details of the same, because we already understand that there is a difference between culpable homicide and murder, and all those exceptions. We talked about the landmark judgment of Nanavati versus State of Maharashtra on grave and sudden provocation, and all those cases on the different exceptions. Just to refer to the aspect of 102, to section, I would rather say, the aspect which is there again reintroduced. I would say reiterated, which is already there under the Penal Code. That is the provision in which the mens rea is kind of superimposed on the other person. That is doctrine of transferred malice. So that doctrine of transferred malice finds place here as well under the BNS. Under section 102, doctrine of transferred malice was earlier there under IPC 301. That whosoever does with a knowledge or intention, same intention or knowledge follows in that particular act. So intention 2, so it reads, if a person by doing anything which he intends or knows to be likely to cause death commits culpable homicide by causing the death of any person whose death he neither intends or knows himself to be likely to cause death, to cause, the culpable homicide committed by the offender is of the description of which it would have been if he had caused the death of the person whose death he intended or knew himself to be likely to cause. Basically, it is a doctrine of transferred malice. Simply to understand this, that if A intends to kill B, but by chance it is not B but C who is killed, then doctrine of transferred malice by virtue of section 102 would be applicable. We all know the landmark case of Surinara and Murthy, in which the person administered poison to halwa, which was taken by somebody else, and the other person died. So the liability is the same based on this particular principle of doctrine of transferred malice. तो ये एक बहुत important concept है जो कि continue कर रहा है हमारे PX में भी. Section में आगे बढ़ते हैं हम लोग और 103 पर आते हैं, which provides punishment for murder. Now, murder has already been defined, and also under the IPC we had different provisions for definition as well as the punishment section. So here there is a new change. If you will see, you can refer to 103 subclause 2 here. 103 subclause 1 is same which was earlier there under section 302. It is a reiteration of the same. But 103 subclause 2 is a new insertion or introduction of a provision that refers to mob lynching. ये mob lynching के लिए provision बनाया गया है और मॉब लिंचिंग को एज सच डिफाइन नहीं किया है। ये एक बड़ी बात यहाँ पर है कि मॉब लिंचिंग को डिफाइन तो नहीं किया गया, ही मॉब लिंचिंग टर्म या एक्सप्रेशन यूज किया गया। अर्लियर जहां पर हम लोग कल्पेबल होमिसाइड और मर्डर के केसेस को सेक्शन 34 या 149 के लाइट में रीड करते थे, जो कि अब फिर हम करेंगे, that same concept of common intention and common object, but a specific reference has been given under 103 subclause 2 that if 5 or more persons, that is precisely to refer that a group of people may be a mob. If 5 or more persons acting in concert, if they have a prior concert, this term is also used earlier under IPC. It was used for common intention, that every person would be equally responsible for act of each and every individual involved in the case, if it is done or committed in furtherance of the common intention. So that is how we see, and we have always construed criminal liability of culpable homicide or murder on those persons, those individuals who are involved in these cases of mob. But now we have a specific reference here under section 103 subclause 2, which refers to mob lynching cases, and it suggests that when 5 or more persons acting in concert commits murder on any particular ground, and that is where the difference lies. On particular ground like race, caste, community, sex, place of birth, language, personal belief, or any other ground, each member of such group shall be punished with death or with imprisonment for life and shall also be liable to fine. One thing I would like to mention here, there is no difference in the punishment. The punishment for murder in subclause 1 and the punishment in this case, subclause 2, 103 subclause 2 also, is same. It is just to mention that in these cases also the punishment is imprisonment for life, death, or the person shall be liable to fine. I would also like to refer that in the notes, if you see, there was or notes on clauses, जो clause introduce किया गया था प्ली के समय, वहां पर एक reference 7 years था, पर वो हम actual act में नहीं दिख रहे, actual provision में नहीं, तो हमें ये लेकर के चलना होगा कि punishment same, it is not different, तो मेंशन नहीं किया गया, एक्चुअल एक्ट में जब आया तो ऐसा कोई 7 इयर्स का रेफरेंस नहीं। मैं ये बात इसलिए कह रहा हूँ कि एक पॉइंट ऑफ टाइम पे रहा हो लेजिस्लेचर के माइंड में या बिल प्रपोज करने के समय ये बात रही हो कि नॉट एवरी पर्सन इज इक्वली लायबल इन दैट पर्टिकुलर मॉब, तो 7 साल से लेकर के मिनिमम 7 साल से लेकर के डेथ तक के पनिशमेंट्स को हम कंसीडर कर सकते हैं वाइल सेंटेंसिंग, लेकिन फाइनली ये बात नहीं आई है। यहाँ पर सेम पनिशमेंट दिख रहा है, चाहे वो clause 1 की बात करें चाहे clause बात करें, so we have to consider what is there in the act and it suggests the same punishment for both in both the clauses under 103, 104. So I am continuing in a sequence. 104, the sequence of the provisions. 104 of the BNS. 104 of the BNS suggests punishment for murder by life conflict. If we all remember, and if we can go back and refer to IPC section 303, which has been declared unconstitutional in the case of Mittu versus State of Punjab by the Supreme Court. And Supreme Court in that particular judgment declared it unconstitutional because it was a violation of grounds Article 14, 1921, precisely Article 14, referred in that case. And there was no reasonable nexus where the court said that why a life convict is undergoing a punishment as in life imprisonment, life convict, if commits murder, this judicial discretion of sentencing is taken away. This judicial discretion or option or alternate of life imprisonment is taken away, and it is a case of mandatory death sentence. So this mandatory death sentence was declared unconstitutional, arbitrary, unreasonable by the Supreme Court, and hence done. Now what we see under the new code, that this has been revived. And this mischief, what we say it from the point of view of the purposive interpretation or mischief rule, or from the interpretation of statutes, this mischief has been done away with by the legislature, and they have provided an alternative. And that alternative is life imprisonment. An important point here, this life imprisonment is for the remainder of the person's natural life. this life imprisonment is the remainder of the person's natural life. So the convict's natural life will be considered if life imprisonment is awarded in this case. So it is a kind of revival of this particular provision, section 303 with an alternate. This expression that remainder of the person's natural life was for the first time introduced in 2013, where anti-rape law was introduced after the recommendations of Verma Committee report. This is Verma Committee report was submitted, and in light of that, this particular expression has been introduced in life imprisonment for the remainder of the person's natural life. So here we can say कि जो लाइफ कॉन्विक्ट है उसके नेचुरल लाइफ उनको लाइफ इम्प्रिजनमेंट प्रोवाइड किया जा सकता है. दिस इज द रिवाइवल ऑफ 303 ऑफ द इंडियन पीनल कोड. मूविंग फर्दर, सेक्शन 105 जो है वो हमारा आईपीसी का सेक्शन 304 है. दिस इज अ रेफरेंस टू सेक्शन 304 जो कि कल्पेबल होमिसाइड नॉट अमाउंटिंग टू मर्डर के लिए पनिशमेंट प्रेस्क्राइब होता है. मतलब पनिशमेंट के लिए कल्पेबल होमिसाइड और मर्डर में जो अलग अलग प्रोविजंस थे पहले भी अभी भी हमारे पास क्लब नहीं किया गया है, अलग अलग ही प्रोविजंस हैं. मर्डर के लिए भी हमने देखा अलग अलग पनिशमेंट का प्रोविजन है और कल्पेबल होमिसाइड के लिए अलग प्रावधान बनाया गया है. वो 105 में रेफर है. इसको हम सीधे सीधे 304 से कंपेयर कर सकते हैं, लेकिन इसमें चेंज है. चेंज क्या इंट्रोड्यूस किया गया है, इसमें पनिशमेंट को बढ़ाया गया है. अगर हम देखें, whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life or imprisonment of either description for a term which shall not be less than 5 years. This statutory minimum has been introduced. This was not there earlier. Statutory minimum का प्रावधान हमारे penal code में अब कोई काफी समय से रह रहा है. पर्टिकुलरली रेप केसेस में हमने देखा जब 1980s में जो प्रोविजंस इंट्रोड्यूस किए गए थे रेप लॉज में, बेसिकली 1983 में जब ऑनरेबल सुप्रीम कोर्ट ने रफीक के केस में, मथुरा के जजमेंट के बाद रफीक के केस में रिफॉर्मेटरी अप्रोच आया, सॉरी नॉट रिफॉर्मेटरी अप्रोच बट द कोर्ट हैज एक्सप्रेस्ड एंग्विश इन दैट पर्टिकुलर जजमेंट. तो उसके बाद जब लेजिस्लेचर ने चेंजेस इंट्रोड्यूस किए तो स्टैट्यूटरी मिनिमम्स को इंट्रोड्यूस किया टाइम एंड अगेन, और बहुत सारे प्रोविजंस में ये इंट्रोड्यूस किया गया. और वो हम अब देख सकते हैं कि कई सारे स्टैट्यूटरी मिनिमम, आई हैव आल्सो मेंशन्ड इट अर्लियर, कि स्टैट्यूटरी मिनिमम्स कई सारे केसेस में आप देख सकते हैं बीएनएस में. और दिस इज वन केस वेयर 5 years minimum punishment is introduced but not there earlier under the culpable homicide not amounting to murder section 304. So this is one just to refer under 105. बाकी सारी चीजें लगभग सिमिलर है. तो ये एक चेंज मैं आपको यहाँ पर मेंशन करना चाह रहा था. 106 का जो रेफरेंस है, सेक्शन 106, वो कॉजिंग डेथ बाय नेग्लिजेंस है. कॉजिंग डेथ बाय नेग्लिजेंस जो सेक्शन है वो 1 जुलाई यानी 1 जुलाई 2024 से इफेक्ट में नहीं आ रहा है. उसको बाय गजेट नोटिफिकेशन the government of the ministry has mentioned that it would not be in effect. So this is for the time being in abeyance, is kept in abeyance. It would not be effective from 1st July. In इस particular case में आप समझ लेते हैं 106 को कि इसको दो भाग में बेसिकली बांटा गया है. और इसका पर्पस वही है जो पहले 304A का हुआ करता था, डेथ बाय रैश और नेग्लिजेंट एक्ट. 304A के साथ समस्या थोड़ी सी ये थी कि कई ऐसे केसेस आते थे जहां पे हिट एंड रन के केसेस होते थे, लेकिन कोर्ट को या कई बार लोअर कोर्ट्स के साथ एक सामने ये दिक्कत आती क्योंकि हाई कोर्ट्स उन केसेस को ऑलरेडी 304 में ट्राई करना शुरू कर दिया था हाई कोर्ट्स ने या सुप्रीम कोर्ट ने. फॉर एग्जांपल जस्ट टू रेफर, लिस्टर पेरेरा का जजमेंट था, लिस्टर पेरेरा वर्सेस स्टेट ऑफ महाराष्ट्र या संजीव नंदा वर्सेस स्टेट एंड सिटी ऑफ दिल्ली. ऐसे कई सारे केसेस आए हिट एंड रन के. सलमान खान के केस में भी कोर्ट ने इस चीज को प्रोविजन को देखा कि 304 में कोर्ट लेती और ये ऑप्शन का स्कोप जो है वो 304A अवेलेबल कर रहा. अभी भी आईपीसी में वो स्कोप था कोर्ट के पास. हमारे पास आईपीसी में ये प्रावधान है that if it is not amounting to culpable homicide, और कोर्ट ने कहा कि अगर वो relevant knowledge है, it is not just rash or negligent, the state of mind is not just rash or negligent. In that case, knowledge may be imputed on the person. After sufficient knowledge, the accused person has a sufficient knowledge that it may be brought within the ambit of the homicide, not amounting to murder. So this was often commonly used in such cases, but now we have specific provision 106 where cases can be tried under 106 where causing death by rash or negligent act not amounting to culpable homicide can be punished with imprisonment of this a term which may extend up to 5 years and shall also be liable to fine. पहले हमने 304 में देखा था कि ये 2 साल तक का की पनिशमेंट थी और फाइन और बोथ. तो यानी डेथ बाय रैश और नेग्लिजेंट एक्ट में सिर्फ फाइन देकर के व्यक्ति जो है या जो कॉन्विक्ट है वो उसको रिलीज किया जा सकता था, लेकिन अब जो है वो 5 साल तक की सजा है एंड शैल आल्सो बी लायबल टू फाइन. एंड इफ such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment in the description for a term which may extend to up to 2 years and shall also be liable to fine. तो इसको हम एक प्रोवाइजो या एक्सेप्शन के तरीके से भी देख सकते हैं. इसको मुख्य सेक्शन में ही प्रावधान में ही जो किया गया है, लेकिन इसको हम एक प्रोवाइजो के तरीके से देख सकते हैं कि अगर जो पर्सन है, जो अक्यूज्ड है या जो कॉन्विक्ट हुआ इस केस, वो मेडिकल प्रोफेशनल, तो उनके लिए काइंड ऑफ रिलैक्सेशन है बाय लॉ that in that case it is up to 2 years, not 5 years, and this is in light of the Supreme Court judgment in 2005. Jacob Matthew का judgment I was taking reference to कि medical practitioners के light में ही let down किया गया था. Williams test का discussion etc. है उस केस में. So that reference we can see under 106. And second part is precisely hit and run. 106 subclause 2 is hit and run. Because here in such cases it has been observed that most of the road accidents which take place after hitting, the driver runs away without reporting the matter, without taking the victim to the hospital, to certain medical facilities, the person runs away. Now, based on this particular observation, this particular provision has been introduced that if such an act is being done, then the punishment increases. अभी हमने पार्ट ए में देखा, यानी फर्स्ट क्लॉज में देखा कि पनिशमेंट 5 साल, लेकिन दूसरे क्लॉज में हम देखेंगे कि पनिशमेंट इंक्रीज कर गया because whoever causes death by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting to a police officer or a magistrate soon after the incident shall be punished with imprisonment of a term which may extend up to 10 years and shall also be liable to fine. So in a way, hit and run के केसेस में 10 साल तक की सजा का प्रावधान लाया गया है, लेकिन ये प्रोविजन हमारे इफेक्ट में फिलहाल नहीं है. कुछ समय बाद हो सकता है गवर्नमेंट इसको फर्दर चेंजेस के साथ या बहु नोटिफाई करे. मूविंग फर्दर with sorry to interfere, sir. You have to conclude your session within 20 minutes. Sir, I will 15-20 minutes because sir आगे के provisions में बहुत ज़्यादा changes नहीं. Okay. Thank you. So it's a kind of reference. So अगर हम देखें बाकी आगे के provisions में कि abatement of suicide जो है one and the same similar provisions जो पुराने IPC में अभी हमारे existing IPC में है, या अबेटमेंट ऑफ सुसाइड है, अटेम्प्ट टू मर्डर है, तो ये सारे प्रोविजन जो है बेसिकली रिएटरेट किया गया है. इवन अटेम्प्ट टू कमिट कल्पेबल होमिसाइड तो पहले 308 में आता था, 307 अटेम्प्ट टू मर्डर था, 308 अटेम्प्ट टू कल्पेबल होमिसाइड. तो ये सारे प्रोविजन जो है इनको वापस से रेफर कर दिया गया है. नया इंसर्शन जो है, इंट्रोडक्शन है, वो ऑर्गेनाइज्ड क्राइम का है, वो 111 में है. Organized crime is a serious offense because it provides also for death penalty. Death penalty introduced किया गया है 2 जगह और नए provisions में IPC में, एक organized crime में section 111 provides for death penalty और terrorist acts के लिए section 113 में which provides for the offense of terrorist act. What kind of change is this? Organized crime has been, there was a convention 2000 में कन्वेंशन आया था, इंटरनेशनल कन्वेंशन है यूएन का, और जिसके बेसिस पे ऑर्गेनाइज क्राइम और ट्रांसनेशनल और इंटरनेशनल क्राइम्स को डील करने के लिए यूनाइटेड नेशंस ने भी सारे स्टेट्स जो रेटिफाई कर रहे थे उनको रेटिफिकेशन के बाद लॉ बनाने की बात कही कि तो इस लाइट में कानून बनाया जाए ताकि ऑर्गेनाइज क्राइम्स को कंट्रोल किया जा सके। उसी लाइट में कुछ चेंजेस इंट्रोड्यूस किए गए, जहां ऑलरेडी जैसे महाराष्ट्र में मकोका वाज ऑलरेडी इन प्लेस 1999 से वो एक्ट इंट्रोड्यूस किया गया एंड मकोका इज ऑलरेडी देयर विद सर्टेन चेंजेस। So it was a state legislation, but there was a need to have it at pan-India level, so that it's a national legislation and all the state or stakeholders were involved, and all the states can have the same similar kind of law at a national level. So in this sense, it's a kind of central legislation on this point, and organized crime has been introduced, has been defined also, and the definition clearly mentions that if kidnapping, robbery, or unlawful activities like vehicle theft, extortion, land grabbing, contract killing, economic offences, cyber crimes, trafficking of persons, drugs, etc. So all these cases, they are basically governed, or they are basically covered by a kind of syndicate. ये एक ग्रुप में एक सिंडिकेट के थ्रू उसको कमिट किया जाता है, क्योंकि ये सिर्फ बॉडली ऑफेंसेस मैं नहीं कहूंगा यहाँ पर, ये सिर्फ बॉडली ऑफेंसेस, ये कुछ केसेस में सोशियो इकोनॉमिक ऑफेंसेस हैं, कुछ केसेस में इट अफेक्ट्स द इकोनॉमी ऑफ द स्टेट एज सच, इन सर्टेन केसेस इट मे बी कंसिडर्ड एज ऑफेंस अगेंस्ट बॉडी एज वेल, जैसे कि किडनैपिंग वगैरह में। लेकिन इसका मेन पर्पस ऑर्गेनाइज क्राइम का हमेशा से प्रॉफिट मेकिंग रहा। ऑर्गेनाइज क्राइम का एक्चुअल पर्पस जो है वो प्रॉफिट मेकिंग रहा है, और इसको एक ऑर्गेनाइज तरीके से किया जाता है, इसीलिए ये बहुत ज्यादा फैटल और सीरियस ऑफेंस माना जाता है। तो इसीलिए ऑर्गेनाइज क्राइम को डील करने के लिए यहाँ पर सेक्शन 111 में इसको इंट्रोड्यूस किया गया, और अगर हम इसके पनिशमेंट्स को देखें तो काफी सीरियस पनिशमेंट मेंशन्ड है। 111 की सब क्लॉज 2 में देखें, if such offense has resulted in the death of any person, be punished with death, imprisonment for life, and shall also be liable to fine, which shall not be less than 10 lakh rupees. Fine is quite high, not less than 10 lakh rupees. It can be 1 crore, 2 crore, or any amount of fine which the court deems fit in this particular provision. Also, abetment, attempt, conspiracy, or knowledge, knowingly facilitating the commission of an organized crime, etc. उसको भी introduce किया गया as a separate offense under clause 3. Punishment shall not be less than 5 years, may extend up to imprisonment for life and 5 lakh rupees. So, different facets of organized crime has been introduced, और serious organized crimes जो है वो 111 में introduce किए गए हैं। उसमें भी आपके सब क्लॉज 4, सब क्लॉज 5, सब क्लॉज 6 और 7 में डिफरेंट प्रावधान हैं जो हार्बरिंग से रिलेटेड है अगर ऑर्गेनाइज्ड क्राइम के लिए है, या पोजेसिंग एनी प्रॉपर्टी व्हिच इज डिराइव्ड बाय ऑर्गेनाइज्ड क्राइम। तो ये कई सारे सर इट्स अ काइंड ऑफ एग्जॉस्टिव प्रोविजन। मैं एग्जॉस्टिव इसलिए कह रहा हूं क्योंकि इसके ऊपर पूरा का पूरा स्टैट्यूट जो पूरे ऑर्गेनाइज्ड क्राइम से डील कर रहा, लेकिन गवर्नमेंट thought it appropriate, the legislature thought it appropriate to introduce in the general law of this country, the major criminal law of this country, that is the Bharatiya Nyaya Sanhita. So this has been introduced under the section 111. So organized crime will be is defined as well as punished, both the cases. So charges, if at all, will be framed under 111. एक reference यहाँ पर ध्यान देने की जरूरत है, बहुत important है, that is the not with respect to this. The one point here is that serious organized crimes are under 111, but the petty ones are covered under 112. तो जो petty वाले cases हैं, जैसे छोटे मोटे theft के cases हैं, या टिकट कहते हैं ऑनलाइन अनऑथराइज्ड सेलिंग ऑफ टिकट्स हैं, ये सारे केसेस जो है वो petty organized crimes में फॉल कर सकते हैं, और पनिशमेंट भी उस केस में कम है, क्योंकि वो 7 साल तक की सजा है। मिनिमम स्टैट्यूटरी मिनिमम 1 ईयर है, लेकिन मैक्सिमम जो है वो 7 इयर्स तक का पनिशमेंट है। तो ये हम बात कर रहे हैं ऑर्गेनाइज्ड क्राइम की। और फर्दर जो एक नया ऑफेंस है वो ऑफेंस है टेररिस्ट एक्ट का। इट्स एन ऑफेंस ऑफ टेररिस्ट एक्ट अंडर 113, अगेन अ न्यू ऑफेंस, स्पेसिफिक ऑफेंस। इट इज a kind of provision which has been introduced in general law, because special law on this particular point is already existing, that is the UAPA. UAPA 1967 is in place, and this new provision 113 which has the same definition and same punishment in all cases has been introduced. But the only point that the government has mentioned, with the legislature has mentioned in this case, is that if there is, the explanation suggests that if for removal of doubts, it is hereby declared that the officer not below the rank superintendent of police shall decide whether to register the case under this section or under the UAP Act of 1967. The entire provision is same with an explanation that whether the superintendent of police or any senior officer and the superintendent of police considers that the case shall be registered under UAP or it shall be registered under the Terrorist Act 113. This has to be seen. Practical application of this provision has to be seen in after 1st of July also, and how the things are going on with respect to 113. But it would be covered. It would be an offence under both. To some extent, it's a discretion available to the senior police officials as prescribed by the law itself. Now, with respect to hurt, we can see the provisions with respect to hurt starts with section 114 and it goes up to section 127. 114 से लेकर 127 तक जो है ये पूरा सेट ऑफ प्रोविजन है. हर्ट और ग्रीवियस हर्ट का हमारे आईपीसी में पहले ये 319 से शुरू हुआ था. हर्ट, ग्रीवियस हर्ट, definition, punishment, and the gravity of the punishment increases with the changed circumstances, because in those cases the gravity increases because some special circumstances or aggravating circumstances are there. So now they have been clubbed together. The only point is that कि कुछ केसेस में थोड़े बहुत चेंजेस, जैसे कि पेन अप टू 20 डेज को 15 डेज कर दिया गया है, या फिर परमानेंट वेजिटेटिव स्टेट के लिए स्पेसिफिक रेफरेंस कर दिया गया है ग्रीवियस हर्ट केसेस में. सो दीस चेंजेस हैव बीन इंट्रोड्यूस्ड विद रिस्पेक्ट टू हर्ट एंड ग्रीवियस हर्ट. And next set of provisions is regarding force and assault. That is starting with section 128 to 136. Force and assault cases may be it is just a kind of consolidation, if we can just see. जैसे कि hurt और grievous hurt में है, ऐसे ही force की cases में भी it is a kind of consolidation. Before force, I just wanted to refer the provision in between, that is 126 127. ये wrongful restraint or confinement, हम 339 onwards जो है wrongful restraint, wrongful confinement and different provisions under the IPC on wrongful confinement exist करता है the IPC में. तो उन set of provisions को अब जो है एक provision wrongful restraint पर है, जो provision punishment दोनों है, offense of definition of punishment, और wrongful confinement के लिए सिर्फ 127 है. It is basically a consolidation of all. यहाँ पर इंट्रोड्यूस किया गया है. I hope I am audible here. So we have force and we have provisions, a set of provisions for force and assault also with a similar kind of provision, except for the fact that we need to understand that this part at the further, when it deals with kidnapping, abduction and slavery and forced labor, it has mentioned specifically and consolidated points on, suppose if we refer kidnapping or giving a child for purposes of begging, and then kidnapping or abducting in order to murder or for ransom, it is nothing but a consolidation of 2-3 provisions. For example, kidnapping for in order to murder and ransom were different provisions. 364, 364A. They have been clubbed together under section 140. Just to give a reference. So 140 is a new provision which deals with kidnapping for ransom as well as kidnapping for murder. Another can be importation of girl or boy from foreign country. Importation of girl or boy from foreign country is also mentioned and was earlier also provision. So under the age of 21 years, or a girl or boy under the age of 18 years is mentioned under 141. It will be covered, and that is shall be punished with imprisonment which may extend up to 10 years and shall also be liable to fine. 142, 143 again deals with wrongfully concealing or keeping in confinement and trafficking of the person under 143, the same definition which was earlier there under section 370, capital A. So the same definition is mentioned again, trafficking. and exploitation of a trafficked person under 144. 145 deals usually dealing in slaves, and 146 is unlawful compulsory labor, which is one and the same as prescribed in the Union Penal Code. However, यहाँ से एक दो provisions जो minor के buying और selling के लिए था, उनको यहाँ से pick करके, उनको वहाँ से call out करके offenses against children वाले पार्ट में डाल दिया गया. बस ये एक मेंशन यहाँ मैं करना चाहूंगा, और बाकी सारा कुछ जो पहले था उसी को कंसोलिडेट कर दिया गया है. तो ये सेक्शन 146 तक हमारा ऑफेंसेस अगेंस्ट बॉडी में ये कवर हो गया है. तो बाकी जो एक रेफरेंस है, इट्स जस्ट बेसिकली फॉर रेफरेंस दैट आई काइंड ऑफ इसको वाइंडिंग अप थोड़ा सा मैंने किया लास्ट पार्ट को, क्योंकि जी तो जी सर
Okay.
थैंक यू.
So I just refer the point which is discussed by Sri Anubhav Kumar in brief, which we are required to consult on the perspective of judicial officers and APPs, who is going to deal with all these cases from 1st July onwards. We have to consider section 103 seriously, that is previous 302. That is the punishment portion. We used to frame charges under section 302. Now it is 101, 103 subclause 1 and 103 subclause 2. If we are framing charges under 101 for committing murder, then keep in mind it may be read with section 34 and 49, but 103 subclause 2 specifically mention about the murder committed by 5 or more persons on the basis of caste, religion, group, community, etc. That is indirectly called as mob lynching. So we have to consider that section seriously. Thereafter, punishment for culpable homicide, which is 5 years minimum, we are required to consider it also. Then if offense of murder is committed by a life convict, then the punishment is death and life imprisonment, and life imprisonment till natural course of life, which is required to be considered in section 104, I think. Then 106, we required to read further and discuss further, and all the judicial officers are required to read it sincerely. That negligent act is now more serious in terms and is widened enough. So we are required to consider it in this light, although at present it is not enforceable. It will be enforceable further. Then 111, organized crime, a new concept for us, either organized crime or petty organized crime, which is required to be considered and discussed further. And a brief idea has been given by Sri Anubhav Kumar, which will be beneficial for us to further elaborate all these concepts. Then terrorist act. That is again a new offense which we are required to read further and think further. From 1st July onward, we have, before framing of charges, before taking cognizance, all this section is required to be considered seriously. So it is a request to all the judicial officers to go through these sections, mainly the session codes, so that they can effectively use this provision before doing any wrong or mistake which will be corrected further. So if we are required to read offences against body with reference to these changes, which is addressed by Sri Anubhav Kumar, and we are quite thankful and grateful to him. He has spared time for us. Now, procedural formalities, vote of thanks हमको देना है, तो I am just proposing my vote of thanks to end or sum up this program. To respected all the district judges, all the respected presiding judges of family court, all the ADJs, learned CJ, learned PPs and APPs, who is attending the program in online mode, and all the learned judicial officer who is here in the academy to participate in the program in offline mode, and all the distinguished guests and dignitaries who has joined this program in online mode or offline mode. I owe my deep sense of gratitude to all my resource persons and faculties for their sincere effort and continuous effort to make this program a successful. I owe my gratitude to all the participants who have patiently participated in program and cooperated us. I owe my respect and gratitude to all the officials of the Honorable High Court and member of Directorate as well as member of government officials who has cooperated to arrange this program successfully and webcast this program successfully. I also thank to all my staff who assisted us in the smooth sailing of this program. So thanks a lot. Thanks a lot to all who has cooperated us in arranging this program, and good wishes to all. Thanks a lot. Thank you.
Thank you. Thank you.
Thank you.